This is our first session of the day. We have stellar speakers. I'm very grateful for the organizers and for our speakers that have made it virtually to appear before you and present hot topics in relation to pressing procedural issues in online arbitration. Now, I want to first update you on how this session will be conducted. We will have presentations of 10 to 12 minutes from each speaker. I will introduce each speaker as we go on. And let me first start by introducing our first speaker, Alexander GREBELSKY. He's the managing partner of GREBELSKY and Partners, and he is the chairman of the panel for international investment disputes at the Arbitration Center, the Russian Union of Industrialists and Entrepreneurs, and the chairman of the Commission on Arbitration and ADR at the Moscow branch of the Association of the Lawyers of Russia. Alexander holds a PhD in law and is a senior lecturer at the Lebedev Department of Private International Law and Civil Law at MGIMO University. He also acts as a deputy director of the Information Center of the Hague Conference on Private International Law in Moscow. His research paper, Evidence in International Commercial Arbitration, was awarded the best paper in on arbitration in Russian during the Russian Arbitration Day of 2019. Alexander will be kicking off by addressing us on the topic of due process and online arbitration. Are they compatible? And then we will move on to the other speakers. I'll introduce them accordingly. Alexander, you have the floor. Thank you.
Yeah, Mohammed, thank you for your kind introduction. You know, when we all faced the need to go online, I immediately had the title in my head from Nobel Prize winner Bob Dylan's rather provocative song, "The times, they are changing." But of course, international arbitration is a field that shall adapt to all changes. And we are lucky because the current problems coincided with the fantastic development and cheapening of video conferencing. A few years ago, it was hard to imagine that such systems as Zoom, Microsoft Teams, and Skype Business would be available almost for everyone. Also, many leading arbitration centers came prepared for this situation and created their own state-of-the-art platforms. At least those that I know in Russia are the RSPP Arbitration Center and the Russian Arbitration Center. Moreover, the White case study in 2018 found that 43% of respondents had already used video conferencing as part of the arbitration. Unfortunately, I do not have statistics from other arbitration centers in Russia, but I know that RSPP, for example, resolved 20% of disputes before the pandemic with the virtual participation of at least one party. However, the trend has now changed from nice to try to need to use. A few years ago, in one of his articles, Arbitration and Fine Dining, one of my favorite authors, Professor William Park, said that a restaurant meal might turn into disappointment both when good food arrives late and when prompt service delivers bad food. The chef cannot choose one aspect of fine dining and exclude others. The same is with arbitration. Justice delayed is justice denied. So we see that arbitration users are interested in holding virtual hearings instead of postponing them. Although not as glamorous as the week of pleadings in Paris or Hong Kong, virtual hearings are in any event the much more practical alternative in the current circumstances. Many institutions have presented special guidelines and checklists for holding online meetings, for example, the ICC, AAA, Vienna, Hong Kong, and many others. Most comprehensive are ICC guidance and SOE protocol on video conferencing, in my view. But virtual hearings raise a host of issues for parties and tribunals, both technical and procedural, that physical hearings do not. As it was said in one of the Lord Atkin decisions back in 1943, when there were no virtual hearings, convenience and justice are often not on speaking terms. We all remember that the most popular topic recently was due process paranoia, that based on the risk that a final award may be set aside or refused enforcement, so-called the enforcement risk, on the grounds of procedural violations. For those who, for some reason, missed the episode from the history of international arbitration, the right to due process is set out in several sources, especially in Article 5 of the New York Convention, which states that recognition of the award may be refused where the party proves that it was not given proper notice of the arbitration proceedings or was otherwise unable to present its case. And now we have a new diagnosis in arbitration psychiatry. Due process paranoia turned into online due process paranoia. The never-ending battle between the interest of justice and fairness on the one hand, and finality and efficiency on the other. Due process, including the right to fair and equal treatment and the right to be heard, are terms that are easy to describe but difficult to define. Perhaps it's better to consider this on the specific elements of the arbitration procedure. So very briefly, first, consent to virtual hearings. Only a few national arbitration statutes contain a special provision on the admissibility of online hearings. I can only say that, for example, the amendments allowing the witness examination without their physical presence are included into the Dutch, Austrian, and Hong Kong arbitration acts. For the contrary, many arbitration rules provide for remote hearings. For example, Article 19 of the OCIA rules, Article 24 of the ICC rules. In Russia, again, for example, the rules of the Russian Arbitration Center, Article 39, and the RSPP rules, Article 47, which I'm especially proud of since it includes the right for the remote witness and expert examination. But what to do when arbitration rules do not directly indicate such an option? Even in a lockdown, parties very often ask institutions to conduct an oral hearing in person because they are preoccupied with procedural fairness, to which a physical hearing may lend a lot of psychological credibility. It's difficult now to predict how pragmatic the approach of state courts will be when they consider the parties' arguments that the hearing took place virtually in the absence of agreement for that, direct or implied. On the one hand, we can assume that extraordinary circumstances will be taken into account. But I think that the admissibility of virtual hearings will, in many respects, be a projection of how acceptable it is to hold virtual hearings in state courts of a particular jurisdiction. For example, the position of the Supreme Court of the Russian Federation is that the hearing takes place online if all parties to the dispute agree on that. Will it extend to arbitration? I think yes. Then hearing notices. Many centers have stopped communicating with parties via regular mail. However, according to the law, in many jurisdictions, an electronic notice of a hearing is again possible only with the consent of the parties. Therefore, those institutions are lucky that have included the relevant section in their rules. Then confidentiality, which is one of the main privileges that may be violated online. However, many institutions have not taken the path of developing their own platforms and do not guarantee the confidentiality of proceedings through these platforms. Again, the SOL protocol introduces requirements that these platforms should be protected. But in accordance with its provisions, it is the responsibility of the parties themselves and not the tribunal to ensure safety. Also, the protocol prohibits the recording of a conference by any of the parties except the arbitral tribunal. On the contrary, as I read in the social networks, now participants recommend recording the hearings to check the reaction of the tribunal. However, this is a typical violation. I won't not go into details, issues related to evidence, as the next speakers will touch upon this, I'm sure. I might only say that, in my view, all recommendations to minimize the length of the hearing, excluding the stage of direct examination of witnesses, excluding the oral arguments, are big mistakes. Then decision-making. Can arbitrators discuss procedural orders or final awards remotely using virtual break rooms, or should they ultimately be gathered in one location? In some jurisdictions, there is jurisprudence that prescribes only the gathering option. In addition, the award, according to many national laws, is made in the form of a single signed document. Is it possible to sign it exclusively in electronic form? For example, under the Russian legislation, it's simply not enough. So, my conclusions. The solution to online due process concerns has to be found in more accurate and realistic assessment of enforcement risk in each case and in each jurisdiction. Tribunal should take comfort from the fact that very few awards are successfully set aside or challenged for procedural reasons, for example, in such closed jurisdiction as China, in only 2% of cases. So don't be afraid to be virtual. I started with the times they are changing, but have to finish with the world famous. Plus ça change, plus c'est la même chose. The more things change, the more they stay the same. The fundamentals of arbitration remain unchanged in cyberspace, and online arbitration compatible with the due process. The proceedings simply should not degrade into a virtual circus. So thank you for your attention.
Thank you very much. That was right on time, and I'm very grateful for an excellent start, Alexander. Just for those who are following, we will have a Q&A session, so you will get to share your comments and questions to our prominent speakers. So thank you very much, Alexander. Let me move quickly to our next eminent speaker, the Right Honourable Dame Elizabeth Gloucester. Dame Elizabeth is joining us. She is, of course, a DBE, for those who are not familiar, Commander of the Most Excellent Order of the British Empire. She's an international commercial arbitrator at 1 Essex Court, Temple, London. Elizabeth Gloucester, if I may, was a Lady Justice of the Court of Appeal until she retired from the court in 2018, when she returned to practice. And I'm saying return because she initially started as a QC and barrister, and she returned to practice as a full-time international commercial arbitrator. Since returning to 1 Essex Court, she has had previously practiced, as I mentioned, as a QC, and she's been appointed as chair and co-arbitrator in a large number of international arbitrations, ranging from banking, insurance, reinsurance, oil and gas, telecom, construction, joint venture to state investment disputes. Name it, and she's done it. She was the first woman to be appointed as a commercial court justice judge in England in 2004. So she opened the door for all those great women that followed suit when she presided many important commercial and financial market cases, including the JP Morgan Chase case versus Springwell Navigation. And she's also a part-time justice of appeal in the Court of Appeal of the Bermuda and of the Abu Dhabi Global Markets Court. Dame Elizabeth will be addressing us on the topic of board virtual hearings and cross-examination, a topic that is indeed very important at these times where we are moving things online. Dame Elizabeth, you have the floor.
Thank you very much indeed, Mohammed. I'd like to pick up where Alexander left off, which is actually there's not much new under the sun. My address will be, I hope, fairly practical, containing hints about do's and don'ts in our new virtual world, particularly related to cross-examination. The first point I'd like to make is that many of us have been cross-examining or listening to cross-examination over a virtual video link for many years now. Some people, although I don't speak from my own experience here, have had the difficult task of cross-examining children on video links in family cases. More pertinently, certainly in my area of practice, is that certainly over the years, I've cross-examined, as I'm sure many of you have, many foreign witnesses who either don't want to or can't come to the physical location of the arbitration hearing or the courtroom. I've often had the experience of witnesses saying, well, of course, I'd like to be with you, or maybe the subtext is, I wouldn't like to be in this courtroom with you, but unfortunately I can't get a visa to get into the UK because I've currently been convicted in my absence of murder and attempted murder and money laundering, and therefore won't get a visa. And when you look at a witness like that across a video screen, a judge or even counsel cross-examining him may perhaps be quite relieved that the witness isn't in the room beside you. But what we've not been doing previously is cross-examining where both the cross-examiner, counsel, and the judge and the victim, in the sense of the cross-examinee, are all operating virtually. And that, I think, and certainly my limited experience so far of virtual cross-examination in a virtual arbitration hearing, is that that gives rise to a very different dynamic. Now, why is that? What is the difference that total virtual hearing room has created? Well, first of all, on the one hand, one is more remote because it's difficult as cross-examining counsel or as the arbitrator to eyeball the particular witness. Do I know who I'm looking at the moment? Do I know who's looking at me on a virtual screen? It's much more difficult to get that personal cross-examiner to witness contact, to get the dynamic going. That leads, it may be the case, to a difficulty in establishing that the witness, by his body language or by the sound of his voice or by the movement of his eyes, is actually telling a lie. It's difficult, it seems to me, sometimes in a both way, all way virtual hearing to establish to the judge or to other people in the room, in the virtual room, that your witness is a lying scumbag, or alternatively, is a man of obvious honesty and truth. And on the other hand, and some of you may have come across this in virtual hearings so far, there is in a way, although there's a remoteness between everybody, there is a sort of sense of informality or common sharing of an experience amongst participants in a virtual hearing. Does that, and I question, I'd be interested to hear your views, actually lead to greater closeness between the cross-examiner and the cross-examinee? Are we all sharing this common pandemic? Does that drip down to our virtual hearings? Obviously, the logistics and the technology make a difference. If something goes wrong with that, we can all be in a pickle. But what does this lead to? Do we have to adapt our techniques? Should we change our techniques altogether for the purpose of conducting a hearing? I've got a few suggestions as to how we might adapt our techniques, both from the perspective of the cross-examiner and also from the perspective of the tribunal. First of all, even if one can't eyeball the witness, even if one can't perhaps impose one's own personality as a strong cross-examiner or an evil cross-examiner or a deceptive cross-examiner on the witness, nonetheless, one can and should try and establish some sort of personal dynamic with the witness. I'm talking about important witnesses whose credibility matters. That we can do that, I think, by using techniques that involve much shorter questions, much crisper questions. That, I think, will lead to an improvement in techniques generally. Secondly, and obviously this is the same thing as today, preparation of document presentation to the witness will be absolutely key. We will need to make sure that our references are absolutely to hand, that we're not fluffing about trying to find the document, whether in the electronic bundle or in the pile of papers on our desk. That will be absolutely critical, to have a good document scheme, a good document presentation with colleagues able to help. But I think the more interesting question, in a way, is whether we should change our cross-examination techniques altogether. Will this lead to the question, and what is the answer to it, as to whether we really need cross-examination in commercial cases? A lot of people take the view, and certainly I've heard this from continental colleagues, that actually cross-examination doesn't get you anywhere, because most cases can be decided on the documents, and people will say what they want to say and what they would like to remember. And really one can't, on critical matters, trust what a witness says anyway. I think it would be a great mistake to chuck out the concept of cross-examination altogether. One cannot, in my experience, both as a judge and an arbitrator, always rely, or often not rely, on carefully crafted, usually by lawyers, witness statements. The really skillful cross-examiner will be able to pull holes in what a witness has purportedly said is his own evidence in his witness statement crafted by his lawyer. Because when he gets away from it, when he's drawn away from it, a clever cross-examiner will be able to establish what actually happened, as opposed to the gloss that often the lawyers will need to put on the evidence. So I think there does remain a real need for cross-examination in this new virtual world. Another possible change in our techniques, as opposed to an adaptation of our techniques, is to tell a witness who's about to be cross-examined in advance of the questions. Let him know what questions are going to be asked. Now, common lawyers will find that an absurd idea, because the whole point of cross-examination, certainly for many counsel, is that you trap, surprise, get the truth out by means of a guerrilla attack from a recalcitrant, dishonest witness. Now, is that an absurd way to approach a commercial case? Would it not be better, say the critics, to let the witness know in advance what questions he's going to face? Wouldn't that cut down the time for cross-examination and make it more efficient and indeed effective in a virtual world? Because one might say it's very easy to see where somebody has been prepared to answer particular questions, as opposed to where he's coming out with his own answer. So that seems to me to be a possible technique. Of course, it'll all depend on the type of case. What I think it will mean is that both counsel on both sides and the arbitrators, the tribunal, will have to consider very carefully as to whether cross-examination is really necessary, what is it going to achieve, on what particular limited points is it really necessary. There may be one factual issue which is not dealt with on the documents, where cross-examination might be really useful. And it seems to me that arbitrators should be flexible enough to say, well, actually, we're not going to have cross-examination on this point or on that point, those paragraphs of the witness statement, but there are particular issues where we want to hear from the witnesses in their own words. And the final point I'd like to make is that I think there should be a readiness or a reality that we have to face up to. And that may be that some hearings are simply not suitable for virtual hearings. Now, Alexander said, or maybe Mohammed said right at the beginning, that of course justice delayed is justice denied. but that's not necessarily the case, where both parties say the outcome of this dispute depends critically on the integrity or lack of integrity of the different witnesses. It is not fair to either side to have all their evidence heard on a virtual link in a virtual hearing room. And I know from my own experience that at least two cases, one a court hearing, a lengthy court hearing involving challenge to the good faith of witnesses on both sides, and likewise at least two lengthy arbitration hearings have been adjourned and have not been deemed as suitable for hearing on a video link. So what can I leave you with? Will there be due process challenges to virtual hearings with cross-examination? Will there be challenges if hearings are not adjourned when they should be? Who knows? All it does do is to raise a lot of questions for we lawyers, which in one rather cynical way has to be a good thing. Thank you very much indeed.
Thank you very much, Dame Elizabeth. Again, right on time. I'm very grateful. I think the virtual environment and online conferencing has shown that we stick more, let's say, strictly to time than in a real life situation or physical type of conferences. My third speaker I have the pleasure of introducing is Roman Kodikin. Roman is not only, of course, a friend, but he's a partner in the London office of Brian Cave, Leighton Paisner. He holds his PhD in conflict of laws, a very close topic to my heart, and is also a visiting professor at Queen Mary University in London. In 2019, the best lawyers named Roman the Lawyer of the Year for his work in international arbitration. He has recently co-authored with Carol Mokai a book entitled A Guide to the IBA Rules on Taking of Evidence in International Arbitration, and it's been published by Oxford University Press in 2019, quite an impressive publication. Roman will be addressing us on the topic of presenting evidence in an online arbitration, which I think ties in very well with Dame Elizabeth's seminal presentation on cross-examination. And just for the record, it was Alexander GREBELSKY who said justice delayed, justice denied, but I firmly believe in it as well. Roman, you do have the floor. Thank you.
Thank you very much for very kind introduction, Mohammed. Now I'm going to talk about presenting evidence in online arbitration. So we have now entered into a completely new era where physical face-to-face hearings are no longer possible, at least for the nearest future. And are we ready for this reality? And here I'm going to quote Sophie Nappert, who said that there are 4 stages of acceptance. The first one, this is worthless nonsense. The second one, this is an interesting but perverse point of view. The third stage, this is true, but quite unimportant. And stage 4 is, I always said so. So the fourth one is very famously used by the President of the United States often. So COVID-19 effectively enhanced transition through these stages, and we are now fairly squarely in the 4th stage. So whether we want it or not, we need to grapple with the online arbitration if we want to continue operating in this field, at least for now. So my topic covers 2 broad areas. The first one is gathering and presenting evidence during the arbitration, and the second is presenting evidence at a hearing. So starting with the first one, the first stage is the evidence gathering. Before any case commences, or kind of at the beginning of the case, we as lawyers need to collect physical documents. We do sampling, carrying inspections, interviewing witnesses. So the COVID-19 is now causing difficulties in gathering evidence. There's still various ways to deal with evidence gathering. For instance, we can do video interviews or virtual inspections, but still it's not the same. We know that, for instance, experts cannot get to vessels now to inspect cargoes, and the parties have no choice but to use, for instance, local contractors who may not be necessarily experienced to carry out such an inspection. And contemporaneous evidence, like photographs and videos, is becoming ever more important. So the second question is how we can present evidence in an online arbitration. Again, with the offices closed and printers unavailable, the parties can still share the documents in electronic format. So emailing exhibits, emailing evidence may be, an obvious but very difficult route, because it's only possible for smallest document sets. Otherwise, something else should be used. So in that respect, we will probably see emergence of document management platform used by different arbitral institutions. I personally like the document management platforms used by some of them, or in particular, I had great experience in using the American Arbitration Association platforms many years ago now. They were pioneers in a way, because effectively the way it works, each case is getting a special protected folder on the platform, and the party submits pleadings by simply uploading the documents into the folder. So once done, the party submitting evidence doesn't have to send print documents and send them across the globe. So once the documents uploaded, all other parties, as well as tribunal members, receive an email notifying about the filing, and so everybody can from that point can access the folder and see the evidence which is in there. Now, document production, again, that's another point, which is first, COVID-19 in some instances has made it difficult to conduct any meaningful document production, specifically if there is no access to paper archives or document storages. But even before COVID-19, we've seen a big push in terms of digital document production. Given the volume of documents held electronically nowadays by most commercial parties, it's simply not feasible for a manual search or review of these documents. And out of necessity, the parties must therefore employ search parameters as a filter to catch documents which may fall within the category. So the skill of the lawyers in this exercise is to formulate initial search parameters that are not too narrow and not too wide. Now, an increasingly common trend today is for the parties to use special electronic document management platforms. And more recently, various electronic platforms have been developed what is known a predictive coding. So predictive coding effectively is a machine learning technology driven by human tuition. It's an algorithm in the software used to harvest relevant documents. So we are using a lot these document predictive coding machines, but naturally we see that there is a concern that the machine search will miss an important document. And on that basis, some parties still insist on manual review. However, there is evidence that the results of a predictive coding review are statistically superior to a traditional manual review. This is because in traditional manual review, there is still risk of human error. So a machine normally does not miss a document. It can be there can be programming mistake, which will allow a document to go undetected, but normally machine will not miss documents simply because it is typed. And I should say that in England, back in 2016, we had a case where the judge, the other side, insisted on more traditional keyword search to be used. And while we insisted that predictive coding should be used, and that was case Brown and BCA Trading Limited, where the judge agreed with us and said it would be disproportionate to conduct, not to use a predictive coding in this case. Another related issue is how reliable electronic documents might be. Again, we have all seen cases where evidence was tampered with in terms of dates or in terms of what a document actually says. Will remote gathering of evidence encourage more tampering or even kind of forgery? So the reality is that it is far easier to conduct examination of the electronic documents. And for instance, it's possible to examine metadata as long as a document in native format is provided. Then one will be surprised how accurate this forensic examination of the electronic document can be. So for my part, I think moving to some form of digitalization may decrease the amount of tampered with documents or forged documents. Now I'm moving to my second limb of my presentation, which is how to present evidence during an online hearing. So while the parties have now moved to remote hearings, this does not relieve the parties from the burden to prove their respective cases. So therefore, all evidence should still be presented to the tribunal, be it electronically or otherwise. So instead of traditional multiple set of paper bundles in online arbitration, the parties have to run paperless hearing. And there have been cases where all participants still had traditional documents while conducting a remote hearing, but it is less and less common. So whether you like it or not, nowadays the bundles have to be electronic. So what are the options for the parties? There are various products available on the market, such as Magnum, Opus, but the parties are also using Zoom or Blue Jeans, which are fast becoming a mainstay of business meetings and distant learning. So also less advanced technology might include Excel file with hyperlinks to subfolder documents, or some parties use online data room. For instance, we used successfully a program called HiQ. What is important is how these platforms can be used to present evidence in an online arbitration. Effectively, what we need from that platform. First and foremost, we need to be able to simply show a particular piece of evidence to the tribunal. Some tribunal members will also find it useful if they can annotate a particular document, and we should be aware that not all platforms allow this. For instance, Magnum will allow this by default, but other options may be more ad hoc, so you need to discuss it with service providers as to whether it's possible. And second, we need a witness giving evidence remotely to be able to not to have any advantage or disadvantage in terms of the materials available to the witness. So therefore, the platform should give the witness access to all documents he or she can be cross-examined on. So this consideration should be kept in mind while deciding how one is going to present evidence in an online hearing. So by way of example, Zoom, the most kind of commonly used software now, offers a screen share facility which may be helpful for short exhibits. So you can show a short exhibit to the tribunal, but it's not as helpful as other more tailored platforms when it comes to longer exhibits. I personally would definitely recommend investing time in hyperlinking bundles, including the indices of core documents or authorities, because that is really time well spent. And Dame Elizabeth, in her infamous judgment in Berezovsky and Abramovich case, actually praised Opus Magnum system for hyperlinking documents and how useful it was for the judge to decide the case. So also worth mentioning that technological service providers such as Epic or Opus, working in conjunction with hearing centers, have made great strides in addressing these perceived challenges of virtual hearings. As part of their services, they offer dedicated technology operators. Effectively, you have an operator who participates in hearings remotely to manage the video link and deploy documents from electronic hearing bundles. And as a result, participants in a hearing are able to see the documents on which a witness is being examined, for instance, or which counsel is referring far quicker than in traditional hearings, because in traditional hearings, you know, we wanted to take a bundle and to flip through the pages. So here, this document will just pop up on your screen. Now, there are a couple of problems I want to mention in the time available. The first one is, as Alexander already envisaged in his speech, the data protection and information security presents significant concerns. So it may be easier to protect or address this if the conduct of remote hearings is managed through the Arbitration Center. And another interesting issue which may arise is sequestration of witnesses. We know it's a practice that requires a witness not to be present at a hearing before that witness has given testimony. And the basis of, for sequestration is that attending a hearing before giving evidence will permit a witness to tailor his or her subsequent testimony. So, although it's not common in arbitration, it's not kind of commonplace in arbitration, specifically when a witness is also a party. Some tribunals still prefer that witnesses to be sequestered, and this is something which needs to be also addressed in an online hearing environment to make sure that the witnesses are not able to see the evidence of other witnesses before they're called to testify. So this, in a nutshell, the biggest issues which arise in online hearings in terms of presenting evidence, but there are many more, and yeah, I'd be happy to take any questions afterwards. Thank you.
Thank you very much, Roman. Very insightful, and again on time. Let me move to our fourth speaker, my great friend Kathleen Paisley. Kathleen will be addressing us on cybersecurity and online arbitration. She is a well-known international arbitrator based in Europe and in the United States. And she's got special expertise in complex technology, data, cybersecurity, and life science disputes. A very interesting combination, and certainly Kathleen is an authority on these matters. She is triple qualified with a degree from Yale Law School. She's a certified public accountant and has an MBA in finance. So she's a tribunal in her own standing. Prior to becoming an arbitrator, she was a partner with White & Case and Morrison & Foerster. She is currently the co-chair of the ECHA IBA Task Force on Data Protection in International Arbitration and a member of the Cybersecurity Task Force. Kathleen will be, of course, as I mentioned, addressing us on a very important topic that I think will stay with us for quite a long time, cybersecurity. And Kathleen, you've got the floor. Thank you.
Thank you so much. And thank you to my co-panelists for those excellent presentations, and for the Center for organizing this, and of course to Mohammed for that too kind introduction. I'd like to take a step back from what we've been talking about so far and think about the framework in which all of what we do sits. At the moment, we've been doing online arbitration in some form or another since there was an online platform on which to do it, and Mohammed has been writing and thinking significantly about that over the years. Primarily, other than in consumer disputes, the online aspects of both arbitration and court proceedings have been limited, right? I mean, in major disputes, we haven't done cradle to grave arbitrations online until the present circumstances. Perhaps in some SARS cases, I should say, cases where SARS was impacted, but for the most part, we haven't done that. And now we're being forced. Charlie Morgan said the other day that we've been forced to go a decade forward in a month, which I think will be good for the international arbitration community to really force ourselves to become more tech savvy, to bring technology into what we do, both in the traditional arbitration space and the pure online arbitration space. And what we're seeing today is the two are coming together. So what does that mean for security? I think there are two ways to think about security. One is the technical aspects of security, and the other is the people aspects of security. What I think when I was involved in the cybersecurity task force that did release its guidelines, its protocols last November, it was obviously long before current circumstances hit us. But what we focused on very much was the individual aspect of security for each case. Obviously, the security that is required, both as a technical matter and as a people-related matter, differs very much depending on the nature of the evidence being presented, the amount of personal data that's being presented, the amount of cross-border interaction that occurs. All of those impact the nature of the security that should be considered for that case. But the first point I would mention is that security should be considered for each case, even those that were not any more online than they were 6 months ago. Because no matter whether we're going more virtual or less virtual, a major aspect of what we do has been digital for some time. And we need to consider how security impacts that. And if you read many of the protocols for virtual hearings, many of the protocols for digital communications, security and data protection does not present itself at a very high level. It's there, but it's there tangentially. I do think that we have to be cautious because each of these aspects where we go increasingly virtual is for the most part good, and I strongly support them. But the first time we have a major security breach during an international arbitration that causes problems for the parties, there is going to be a step backwards significantly. So we should do everything we can to avoid that. Now, what do I think that should be myself? I take from Roman, I'm starting from Roman's point about the use of platforms. If you go back and you look, I would highly commend to you the Task Force Protocol on Cybersecurity. If you review that and you think about it in the practical context of a particular case, most of what is being thought about there, what's outlined there, is much better handled through the use of a platform. The platforms are available at various price points, various degrees of sophistication, depending on the institution. I agree with Roman, the AAA ICDR platform is excellent. I think the Swedish Arbitration Center's new platform, which is based on IQ, is also excellent. And those platforms are good at establishing a basic security level to the extent that parties use them. The problem is that, like with everything, sometimes the abuse is greater than the use. And so if every document that is filed through a digital platform is then downloaded and used by the entire law firm, through email, then the security aspects are minimized. Now, none of this is really brought about by the current COVID crisis. It's just the way things are when you're doing digital communications and major international arbitration cases. You need to think about security. And what I'd like to tie this in a bit to data protection, in the sense that we, as a community, we understand that we have some degree of obligation to comply with a certain level of security in our cases. But to some extent, particularly now, that is taking second seat to the urgency of the situation. And I do think we will get a buy on both data protection and using perhaps lesser security than we should for some cases. For example, Zoom is not the most secure platform. Zoom has had significant security issues. They've just hired a whole slew of people to try and correct those security issues. But if if a case goes awry due to a security breach in Zoom, there will have been a pattern in practice before that would say we could have predicted that. So I think we have to really think about what platform, and that is not to say you should not use Zoom. It's to say that you need to think about how you use Zoom, when you use Zoom, when you want to use Opus 2. I mean, those are the kind of things that we should all be thinking about. With respect to data protection, of course, the importance of that is it makes all this lawfully required and in Europe subject to significant fines. So every time we have a case that is governed by the data protection laws, cybersecurity becomes mandatory. And if cybersecurity and non-cybersecurity, just plain old information security, is breached, there are very significant requirements for how quickly you have to notify and who you have to notify. And all of these things are better dealt with if they're thought through in advance. So what I do think is happening is, because of COVID-19 crisis, people are talking about what platform they're going to use, and they're addressing security issues at some level for the virtual hearing. What I'm not seeing as much of in the online space as I would like to see is a considered discussion of these topics in the context of a protocol, perhaps addressing all data protection issues, which are much broader than just cybersecurity from the outset. Because if you don't address these issues early, not only with respect to a potential virtual hearing, perhaps more importantly with respect to the exchange of documents, then you create a situation of potential abuse by the party. The data protection laws create a regulatory environment where parties have the ability to use those laws to their benefit and to delay proceedings and to create potential injustices. And those issues are really much better addressed early on. With respect to the specifics of security in the online context, the main thing to think about is these are case-by-case determinations. If you have a simple contract dispute where there is not significant personal data or highly sensitive data being exchanged, that's one set of issues. If you have a highly sensitive investor-state case where governments could fall or people could be assassinated, that's another set of issues, both with respect to security and to the way we do everything, of course. But it's finding the right balance in each case, and that can be done if the tribunal, together with the parties, talks about this at the earliest potential time during the case. And in the cybersecurity protocol, what we recommend, and what I highly commend each of you, is address not only cybersecurity, but data protection in the initial procedural conference. And if you're already almost through your case and you're just thinking about these issues now, to address them now. And to look into what you can do, what you should be doing to secure the security of the proceedings. What that means is very specific. My own advice, what I do whenever possible, is use a platform. If it's depending on who's the institution, that may be an institutional platform. It may be a platform that is standard. Opus, HiQ is excellent perhaps for slightly smaller cases. But I do think the use of a platform avoids having discussed these very specific technical issues with respect to every matter. But sometimes use of a platform is just not feasible economically or because of access by one or both of the parties. So my bottom line advice is take cybersecurity seriously, number one. Number two, address it early and practically within the context of that case. Number three, make sure you know what happens if there's a data breach, and data protection is important. And don't forget about data protection, because we're not going to get by forever. Thank you.
Thank you very much, Kathleen. I think that's it's a great presentation on topics that I think, as I mentioned, will stay with us for quite some time. We will get to have some questions toward the end, as I mentioned, but let me move forward with our final speaker for this session, Andrei Panov. Andrei will be addressing us on the topic, what to do if a virtual hearing is not an option. Again, a very important topic. And I have the pleasure of introducing Andrei, his counsel in Allen & Overy's dispute resolution practice in Moscow. He's also a member of the Russian Arbitration Center board. He has over 12 years of experience representing clients before Russian and foreign courts, as well as before international arbitration tribunals. A one-stop shop for all types of disputes, arbitration, and litigation. Andrei has acted as lead counsel and conducted his own advocacy in a number and numerous commercial, construction, and investment arbitration cases before major institutions, the ICC, the Stockholm, the LCIA, and the SIAC, and the International Commercial Arbitration Court in Ukraine. He has also represented clients in many high-profile commercial corporate disputes at all levels of the Russian courts, with some of his cases becoming cited as precedents before the Supreme Arbitration Court in the Russian Federation. Andrei has advised clients on litigation proceedings conducted in foreign jurisdictions, including in England and Wales, Switzerland, Cyprus, Jersey, the British Virgin Islands, Marshall Islands. Andrei sits as an arbitrator in domestic and international cases on the various sets of rules, including the ICC and the ICAC. He is a fellow of the Chartered Institute of Arbitrators, counselor of the LCIA European Users Council, and co-chair of the LCIA Young International Arbitration Group, and a member of the Vienna International Arbitration Center Advisory Board. He is recognized in all major legal directories, including the Legal 500, Chambers and Partners, Who's Legal, and Best Lawyers. Andrei, as I mentioned, will be addressing us on a very important topic about virtual hearings not being an option. Andrei, you have the floor. Thank you.
Thank you very much, Mohammed, and thank you very much to the organizers for inviting me to speak today. Now, I think we all know who of the speakers did send to you the longest introductory paragraph about himself. I would like to start with Alexander addressed us on a duty to act fairly and due process requirements. And I would like to start with another duty, which is there in many arbitration rules, and this is the duty to proceed in expeditious and efficient manner as you move along with your arbitration proceedings. And some rules, I have to say, treat it as a duty of the tribunal alone, and this would be, for example, Vienna rules, SCCs, so Stockholm Chamber of Commerce rules, or SIAC rules. Others would say that this is a joint duty of both parties and the tribunal, and for example, this is the case with the LCIA rules, the rules of the ICC Swiss rules, and Hong Kong International Arbitration Center. To my mind, this duty under the current circumstances would call for virtual hearings in many circumstances, but obviously there are instances where the virtual hearings would simply not be an option, or at least would not be appropriate. This could be the case due to the parties agreeing not to proceed with virtual hearings, so not the case when one of the parties wants that and the other party says no, but rather the case where both parties say, no, we can't proceed virtually. Obviously, in this regard, the tribunal is bound by the parties' agreement as to the procedure, and not much could be done. This could also be the case where there is a significant imbalance between technical abilities of different parties, and there are many protocols out there, and one of the protocols was adapted, for example, by African Arbitration Academy to deal with the issues, primarily technical issues, which are there in Africa, which we couldn't quite appreciate from here in Europe. We take it for granted that the internet connection is everywhere available and is of good quality, but this is obviously not the case. There could be other specific considerations, such as where there is a key witness and there is a real danger that he or she may be influenced unduly, or where the hearing is so big that it's just too difficult to organize and manage it virtually, as Elizabeth GLOSTER alluded to. Now, if the virtual hearing is not an option, arguably the duty I referred to also requires taking measures to keep things moving notwithstanding. in the hope to remove or at least to minimize the need for in-person hearing, which would be possible at some point in the future. So what could be done to keep the cases moving? I think ICC guidance note on possible measures aimed at mitigating effects of COVID pandemic is very helpful in this regard. You can take a look at section 8 yourself. There is nothing new there, but it just focuses the attention of the parties and the tribunals as to what measures are available. And I would discuss only a few of them. I will start probably with documents-only arbitration, because we talk about virtual hearings as if the hearing is required in every single case. But in reality, documents-only arbitration have been there forever, and they have been very successful in many cases, including very large cases if you judge by the numbers and the price of the dispute. And also pretty complex cases as well. I have heard somewhere that 80% of LMAA cases are resolved on documents-only basis. The maritime cases are not necessarily that simple and straightforward. Still, it is doable. Now, when we talk about documents-only arbitration, I think we need to think about whether we actually need a hearing and why do we think so. There are obviously hearings where you only address the tribunal, deal with the tribunal's questions, address them on the points of law. Well, first of all, this could certainly be done virtually, but also this could probably be done on paper only. And if the tribunal does have questions, then the questions could be raised in writing and could be answered in writing. This is not ideal, but at least this will allow the case to move forward. Now, so if your case doesn't have witnesses or experts, I think this is the good case for documents on the arbitration, at least under the current circumstances. But even if you do have witnesses there, or experts indeed, do you actually need to cross-examine them? Or could you just proceed on the basis of their written statements and agree that those could be challenged without cross-examination? In addition to documents-only arbitration, you could also apply some other techniques, and I'm thinking in particular about bifurcation of your proceedings. So if there are any dispositive issues you have there, such as statute of limitation, you could try to get that out of your way first and get the partial award issued in this regard, and probably get your entire case dealt with by this dispositive issue. But even if the issue is not of that kind, it could many things could still be addressed as preliminary issues, and with the hope to limit or indeed eliminate the need for future proceedings. In the end of the day, you could also have some parts of your hearing or hearing on certain matters done online or virtually. So if, let's say, the reason why you do not want to proceed with a full virtual hearing is because there is an apprehension that one of the witnesses might be influenced, or there are real technical difficulties on the side of one of the witnesses, you could probably get some part of your hearing done online. For example, you could do the legal submissions, you could cross-examine experts, but perhaps in some witnesses, and then reserve the remaining witness for in-person hearing in due course. One other suggestion would be to conduct the midstream case management conference to actually check where all of the parties and the tribunal stand. The parties could try to agree on some facts. They could try to agree on joint chronology of the events. They could try to agree on the list of issues which have been agreed and which are still in dispute. And following that, one could try to revisit the need for the hearing again, because probably once all of this is done, one could see that there is no need to cross-examine any witnesses at all, because any disagreements between the parties could be resolved on the basis of documents only. The experts could try to produce a joint report to narrow down the issues, and again, after that, one could revisit the necessity of cross-examining the expert witnesses altogether. in the end of the day, one could think about appointing the tribunal-appointed expert instead of party-appointed experts to deal with the discrete technical issue or issue requiring specific knowledge. And then finally, one could think about getting the preliminary views of the tribunal in order to help the parties settle the case. Obviously, this is somewhat unheard of in common law world, but this is a common practice in Switzerland and Germany and Austria, and it's been done there very successfully and without any issues of due process. So there are ways to deal with the current situation. But pending cases aside, I think more importantly, I would suggest that we actually need to think more carefully when we're preparing new cases which are being filed now or which are going to be filed soon. Because it is not clear when the in-person hearings are going to be available again. It is not clear if the virtual hearings are going to be available in the appropriate moment. So we need to think carefully about how we present and structure our case. Do we actually need witnesses at all? Are we relying on them out of necessity or just because this is the habit and this is the way we've done it before? Do we actually need party-appointed experts, or could we agree on having a tribunal-appointed expert if the issue is not terribly controversial? Do we need lengthy submissions and multiple exhibits, which will be impossible, or next to impossible, to handle during the virtual hearing and virtual cross-examination? And I think we all know that actually, having submitted thousands of exhibits, we only refer to a handful of them during the cross anyway. Do we need to argue every single possible theory of the case, or could we try to focus on something really important there? And just generally, how can we structure our cases more efficiently so that even if the new pandemic strikes and the in-person hearings are not available again, we could still get the case moving and get the issues resolved? So to conclude, I would say that we as an arbitration community and as arbitrators, as counsel, we shall keep in mind all of that as a part of our duty to deal with cases expeditiously and efficiently. And I would say that the current crisis is, to my mind, in a way, a chance for international arbitration to regain its flexibility, of which we started to forget a little bit, and to become a more efficient process altogether. And I'm pretty sure if we do that, and if we use this chance, our clients and users of international arbitration would be grateful for that. Thank you very much.
Thank you very much, Andrei. That's, again, on time. I think we are directly on time and manage things very well. I'm very grateful for all your seminal presentations, a lot of food for thought, a great way to start this great event. We have time for the Q&A. And let me, since I can't be physically there to clap for everyone, I will ask each member of the panel in a minute or so to share their thoughts on that question. So the first question is actually directed to Roman, and that is, how can an arbitrator check the authenticity of documents presented to him or her, knowing that it's false or not false? That is a question addressed to you.
Okay. So it was difficult even before the COVID-19, and in some instances, we've probably all been in cases where it turned out at the hearing, when the physical document was presented and inspected by the tribunal, that something was wrong with the document. So nowadays, if we're talking about an electronic document, there are various ways to check authenticity. Once the document provided in a native format, you can ask technical specialists. And I had a case where we had in dispute the authenticity of emails. And apparently for instance, all emails sent using Gmail account are verifiable. There is special software. And the expert actually showed that by adding his name on the bottom of email, and the test became negative. When it comes to a physical document, even now we can do it because the tribunal members are normally not experts. In any event, if they want to establish authenticity of document, they would send it to a forensic expert to conduct forensic examination. At the end of the day, the tribunal will probably still look at the expert report and you know, if it's impossible to see the you know, the signs of backdating on a particular document, they will still rely on expert report. And finally, I think that's where we as lawyers can help, because normally when the document is backdated, you can prove it with contemporaneous evidence that it is backdated. You can check, you know, the logs, you can check inconsistencies in all other documents. You can see, we had a great case many months ago when we had a backdated document which was printed on a letterhead. And the letterhead which the party used actually was introduced 2 years later than the date on it. We just compared all documents on the website. It was actually a state authority and of one state, and so the later it was court in arms, and there was no heraldic shield around it. So a very simple analysis was actually helped us to prove that the document was backdated. So there are various ways, but at the end of the day, if it's an electronic document, send it to expert. Even if it's physical document, and even if it's an online arbitration hearing, you can still send this physical document to the expert, and the expert will be able to conduct examination wherever he is or she is.
Thank you very much, Roman. And I take your point that this is precisely what counsel should do. But are you suggesting that a tribunal would do this authenticity test on its own without involving the parties, or in cooperation with counsel, or in relying on the evidence presented by counsel?
No, I think it all depends whether authenticity is an issue.
Yeah.
Because there are many cases where the parties do not dispute authenticity, and at that point, you know, there is no need for the tribunal to go on its own volition to check authenticity of a particular document. But if authenticity is an issue, obviously counsel will be involved for both parties.
Thank you. So Dame Elizabeth, I think, had a comment. Yes.
Yeah. Can I endorse what Roman said? I've come across in my judicial career and my arbitral career many, many examples of forged or backdated or added to documents. And it doesn't make any difference whether they're electronic or otherwise. On the whole, it's very easy to spot whether they've been forged or backdated, because inevitably, unless the perpetrators are very, very clever, there's always something, whether it's style, letterhead, telephone number, that messes up. And in my experience, it's never been difficult when a counsel has raised the issue for the tribunal to say, yes, it is, no, it isn't. So I would echo what he said. And today, with these forensic electronic experts, it's even easier, because you go into the metadata, and again, it's blindingly obvious if the document has been concocted later than the document bears its date. So certainly I think counsel has got to raise the issue. I don't think it should be a matter for the tribunal to say, we want experts on this. I think it would be appropriate for a member of the tribunal to say, I think this looks a bit suspicious to me. And if the parties have agreed it, that's fine, because there may be an innocent explanation. But certainly I don't think it would be unfair or misuse of process for a member of the tribunal to raise his or her concerns about the authenticity of the document. But others may disagree with me on that.
Thank you very much.
You can still disregard the document, a particular document, when you are assessing evidence as a whole. even without expert evidence, you can say, you know, kind of the other evidence, you know, this piece of evidence is not corroborated by other evidence. It's still open to the tribunal.
True, but I think, Rowan, the point that Dame Elizabeth was making is that one member of the tribunal might have a degree of suspicion or skepticism that may or may not be shared by other members. So then the question is, if one sees it that way, first, would you flag it to the parties? And I think that is a question that people may have different views on. And secondly, if you flag it, how do you flag it? Do you present it as there is a degree of discomfort to see whether this document is or is not, and then if counsel puts it to bed, that's fine? I think it's a very interesting question to discuss. And as I fully agree, I mean, it's counsel, of course, need to do their work and assist the tribunal with findings in this regard. And it's always tricky to find the proper language that goes into the award, because it would be sometimes difficult for a tribunal to say, oh, this document is forged, but it's much easier to say that it's not reliable, or the tribunal does not consider that there is sufficient authenticity of some sort, and there is a degree of skepticism, and outline the different elements that brought doubt to relying on that document without taking a stand. I'm saying this because in some legal systems, if you take the step of saying the document is forged, you have opined on a matter that is not within the jurisdiction of the tribunal. But a lot of interesting questions, of course.
Yeah.
I like uncorroborated. That raises very few. You're not criticizing anybody. You're just saying there's not enough corroboration. It's
right. Yes. Absolutely. And we have another question to Dame Elizabeth. And it's a short one, straightforward. Is it time for courts to go totally online? And they don't mean temporary, they mean fully automated courts.
I'm a great supporter of technology. I'm a great supporter of proposals for online courts. If this question comes from Richard Susskind, Professor Richard Susskind, who's written loads of books about this, then he should identify himself. If it's not from him, I think there are huge steps that we should be taking towards online courts. However, there are many cases that in my view are not suitable for online courts, which would include a lot of criminal and family cases, and indeed a lot of commercial cases. And the same goes for arbitration, actually. I think that although we can do an awful lot more than we were doing pre-COVID online, I think certainly as at present advised, we shouldn't swap wholesale actual hearings for online hearings in arbitration. I think we should be doing much more, if only to save the planet, online. I mean, the notion of traveling across the world from wherever one starts to do a one-day case management hearing does appear to me, irrespective of COVID, not to be a good idea. But who knows? I mean, I have traveled across the world to do a one-day hearing. So there we are.
Thank you very much. Now, on the point that you mentioned regarding the unsuitability of certain cases, and you cite criminal cases, is that born out of tradition and belief, or is it something that you have strong views about? Because there are instances around the world in the past few weeks, we've seen jury trials, we've seen death sentence passed virtually as well. Is that something that you think would be developing, or is it an outright no regarding criminal proceedings?
No, it's certainly not an outright no. I think it depends on the type of case and also what the backlog is. I mean, for example, there are some countries we all know where the backlog of criminal and civil cases is so great that the only way of disposing of the backlog is to deal with a lot by virtue of online disposition. So no, I'm not speaking from tradition or anything like that. I'm just saying that I know if I was accused of murder, heaven forbid, or was accused of some really serious offense, I think that I would prefer to see my accusers face to face. I think I would prefer to have the judge there face to face. And likewise in a commercial dispute. And I've had this expressed very strongly to me by clients that they would prefer to present their honesty and integrity in person to a judge or to an arbitral tribunal. Now, that may be old-fashioned, but I think there is still a real role for actual hearings.
Thank you. Yes. Kathleen, you have a comment before we move to the next question?
Yeah, just a quick comment. I think that's absolutely right. But I would say one thing, which is that what I've noticed, both in this setting and in hearings, et cetera, is that actually I wonder whether once we get used to this, the veracity of witnesses and your ability to feel like people are being, straight will be better in the virtual space, because it won't be layered by all the pomp and circumstances and all the, surroundings of a court, but it's the witness and the tribunal. And I think it does, for all the reasons you said in your first talk, I actually think over time, people may change their views on that.
Thank you. We have two questions that are to the panel at large, so I will take a minute from each. One of them actually sprung into existence as a result of the authenticity of the document's response by Roman, but it's addressed to the panel at large. So the question goes as follows. If arbitrators or experts fix, and I'm quoting the question, that concrete documents are false or is false, are they obliged to inform the police or prosecutor officers regarding the fabrication and necessity to bring a criminal case for falsification? And I think they mean forgery. So I think that's a difficult question, but one response from each of our panelists. So let me start this time with Alexander. What is your immediate response to that?
With Andre or Alexander?
No, Alexander first and then
the
Andre.
same question.
That would be me. Okay. To be brief, I believe that yes, the arbitrator should inform officials, since that it's an element of public policy, criminal proceedings and criminal investigation.
Thank you. Andre?
I would say no, because the arbitrator is nothing but a private person. And if the private person believes that something is forged, it doesn't necessarily, this private person doesn't necessarily have the same duties as if he was the public official, like the judge, for example. And also, I think I'll stop there, but I would say no.
Okay, that's an interesting. Before the others give their answers, can I put something into the mix to make it more complicated? If arbitrators are to report that, does that put them in direct conflict with one of the parties that create an opportunity for lack of impartiality and independence to hear the case at large or not? So Kathleen, maybe you have a view on the question and the further complication.
These issues come up all the time about reporting, and I think it's very difficult. It depends on where you're sitting. It depends under what law. It depends on at what place you are in the proceeding. Are you destroying the sanctity of the tribunal? Are you doing the proceedings themselves? How sure are you? All those things. But net, I'd be loath to do it, because I think it does tank the arbitration in most cases. They often settle very quickly, which may not necessarily always be a bad thing, but I'm very hesitant to do it.
Roman, conflict of laws question. Roman, you are on mute, yeah. I think.
Okay. I would probably echo what Kathleen has said, because it will depend on the applicable rules, applicable in terms of as a member of regulated profession, as a solicitor, whether you owe a duty, you're under an obligation to make such a report. And another related issue, to make it even more complicated, some reporting obligations on us solicitors, for instance, or barristers, are to report, for instance, money laundering without telling a party, because that's a tipping off offense. if you tell the party. So it's even more complicated. You've reported them, you cannot disclose that to them, and you cannot say that you're conflicted either, because it may be a tipping off.
And when you apply these bar rules as a solicitor, do they also strictly apply as is when you sit as an arbitrator in a different capacity rather than as counsel? Do you consider them to apply equally, irrespective of the hat you're wearing?
Yeah, I always check whether a breach of this obligation can put me in jeopardy, because effectively, you know, if as a result of this, I will not be able to say I was wearing a different hat, you know, I will tend to report.
Thank you.
Yeah, kind of, it's not a clear-cut question. It's very, very difficult. Yeah.
Thank you. Dame Elizabeth?
As a judge and a public servant, one clearly had an obligation, if one concluded that a criminal offence such as forgery had been committed, to report it to the Director of Public Prosecutions. As an arbitrator, the position may be different, and I agree with Roman and Kathleen. It depends which country you're sitting in, whether as an arbitrator sitting in a private hearing, you nonetheless have an obligation under the money laundering provisions or whatever, or other criminal statutes, to report to the public authorities. So it depends on that. However, I think one would not even start to consider reporting unless the whole tribunal had come to the conclusion that a crime had or had very likely been committed. Again, it would depend on the particular legislation as to what circumstances you were obliged to report. It's not an easy question.
Of course. And is it only a factor of where the tribunal is sitting or where the act has been committed? Because normally criminal acts are subject to territoriality, and it's the place where the act has been taken rather than where the arbitrators are sitting, the seat of arbitration itself. And I fully agree with you. It's a very complex question and complicated in terms of the governing rules and norms and people's perception as well, in terms of whether they render private justice or not. Because there are also instances where some laws in some countries consider arbitrators as delivering a quasi-official or doing a quasi-official public function, or an arbitrator judge work. So indeed, a very difficult question. The final question we have is again to everyone. It's quite an interesting one. So, and it goes as follows. We have seen in arbitrations that emails between the parties informing their conduct, giving context to contractual undertakings or disputes are helpful and can be produced by one party or requested for production during the discovery or production of documents phase. And the question is, with what's happening today, we will have video recordings of meetings online, communications between the parties, and the person is wondering whether the production of video conferencing recordings can be part of the disclosure or discovery process, just like we do with emails, or is there an added element of complexity that we're not aware of? Again, each one of you can give an answer. Let's start this way, the other way around. Dame Elizabeth?
Well, I think my initial off-the-cuff answer is, I hope not. As a tribunal, one gets an awful lot of inter-party and, well, particularly inter-solicitor or inter-legal representative correspondence, a lot of which is not relevant to the issues one actually has to determine. So obviously, if a meeting was relevant, yes, it might be good, useful to look at a Zoom record of the video meeting, or a transcript of it. And it would be better than one solicitor's note, perhaps, of the meeting. But I would hope that one wouldn't be bombarded with Zoom records of meetings or correspondence unless it was necessary for the actual issue whether interlocutory or final, that the arbitral tribunal had to determine.
Thank you. Roman?
So I think speaking from the about my beloved the IBA rules on the taking of evidence in international arbitration, I think it's doable. First of all, the definition of a document is wide enough to capture video recordings, and then it will be the question about whether it satisfies the requirement, whether it's relevant to the case and material to its outcome, what GLOSTER has just mentioned. If it's relevant and material, there may be some other defenses. For instance, if whether it is covered by litigation privilege or whether it's too burdensome to produce. So that kind of Article 9.2 of the IBA rules gives you a list of excuses not to produce a document which is not relevant material, which is privileged, or another legal impediment exists. So I think in principle, if it's relevant and material, not privileged, yes, why not?
Thank you. Andre?
I would say that as a matter of principle, definitely yes, just like any other document or piece of information. But obviously, this is the question, why would you need that? And if it's just for interpretation of contracts, if it's one of the rounds of negotiations, then it really depends on the applicable law. It would not be, most likely, it would not be relevant as a matter of English law, as a matter of most continental laws, it would be relevant. So yeah, I think there would be cases where it would be relevant, but one should think about the ways to produce that, because 8 hours of video negotiations is probably not very exciting for the tribunal.
Thank you. Kathleen?
So, like with everything in my life these days, I have to say this raises serious data protection concerns. Because most of us sit in cases, Russia has a different set of data protection concerns, but they have localization rules. But certainly in a case covered by the GDPR or those 75 other laws that are inspired by the GDPR, this would be serious personal data, and you'd have to ask yourself, is it necessary? Can it be minimized? Is it repetitive of other data? Can the personal information be redacted, which is extremely difficult in the case of the video? Was the recording lawfully made? Did the person who was being recorded know it was being recorded? Did they say in advance that they understood that this could be used in the context of a proceeding? So this puts all the questions about data protection, which do feed in to the new draft IBA rules, in stark reality. So every document that we produce in an arbitration pretty much is personal data. So and all of those documents are covered by the data protection laws. But video, where you're actually, looking at me use my hands too much, that's a particularly sensitive type of information and would need to have serious justification for production. And
so, Kathleen, that's an interesting dimension. So are you saying that data protection regulations would add a layer of difficulty to document production generally, which would make documents subject to a more rigorous production test to pass muster for production?
That is exactly what I'm saying.
And Mohammed, just to add one point, there was a request, a letter rogatory from the US court where they wanted an English court to allow depositions of witnesses in England. So, and as you know, deposition involves video recording. An English court says that the convenience does not outweigh the policy considerations. And they effectively said, you can cross-examine them, you can have a transcript. We do not allow you to have video recording of this cross-examination.
Yeah.
And I would highly commend, not just because it took a year of my life and my children hate me, but I would highly commend to you the IBA roadmap to data protection and international, ICA IBA roadmap to data protection and international arbitration, because we're in the comment period. We'd love comments from all of you. And we're also going to be, this was produced actually on the very eve of the COVID crisis. So it will need to be redone. The standards don't change, but we will need to make some edits to include some more about virtual hearings, et cetera. But yes, that is exactly what I'm saying.
Thank you. Finally, Alexander, you are our last commentator on this question. I think you need to unmute yourself.
Just a short comment. I must say that the position of the Supreme Court of the Russian Federation is that if the video was made during business or commercial relations, not private, then it can be produced. But of course, questions of privileges are the most difficult in international arbitration.
Thank you very much. I think we're right on time and ahead by a few minutes to allow our colleagues to set up for the next session, which I'm sure will be extremely interesting. You've got two more sessions for this great event put forward by the Russian Arbitration Center. I want to thank our panelists for the day for their insightful presentations and answers to the questions presented. I'm very grateful to each and every one of them. In the order they made the presentations: Alexander, Dame Elizabeth, Roman, Kathleen, and Andre, and for the great preparation and technical support we've had from the center. Thank you all very much, and I wish you all a very pleasant day. Our session comes to a conclusion. Thank you.
Thank you very much.
Thank you very much.
Thank you.
Mohammed.
Thank you, Mohammed. Great job.
Оповещение Олег Прусаков говорит.
Hello, everyone.
Оповещение Олег Прусаков говорит.
Our second session of the online conference.
Оповещение Олег Прусаков говорит.
Arbitral institutions, challenges and changes. Hi, everyone who joined us. We know that there are a lot of participants from many countries. We have very distinguished panelists today. I would say very international, from all over the world, from various time zones. So thank you very much for joining us today for this session. It's a great honor and a great privilege for me to moderate this session today. Apart from this, I would say that I'm simply very happy to see you all, at least virtually, here. So first of all, I would like to give short description of each of the speakers to introduce our speakers today. So usually I would say on my left or on my right, but in this online format, I think I will start with the ladies first. And I would like to introduce Sarah Grimmer, Secretary General of Hong Kong International Arbitration Center. Sarah was formerly Senior Legal Counsel at the Permanent Court of Arbitration, PCA, in Hague, where she acted as registrar and interstate arbitrations, in multiple investment treaty arbitrations, and also contract-based claims. So, Sarah, thank you very much for joining us from Hong Kong.
Thanks, Andre.
We also have today Jacomijn van Herscholte van Hof, Jackie, the Director General of the London Court of International Arbitration, LCIA. Prior to joining LCIA in 2014, she had her own law firm in The Hague. Jackie is also very experienced as arbitrator and active as arbitrator. So thank you very much, Jackie, for joining us today.
Thank you, Andre.
We're happy to see you. So we also have Patricia Shaughnessy today from Sweden, as I understand. Former Vice Chair and member of the Board of Directors of the Arbitration Institute of the Stockholm Chamber of Commerce. Dr. Patricia Shaughnessy is the supervisor of the Master of International Commercial Law program at Stockholm University and also teaches in other related fields. Welcome, Patricia. Thank you very much for joining us. It's a great honor to have you also here today.
Well, I'm happy to be joining. I only wish that we were live in St. Petersburg.
Yeah, yes, this is something that I will speak also about. And I also wish that I could meet you all in person, as always, in May and enjoy the great weather in St. Petersburg. We also have Miroslava Shirholz, Mira, Assistant Vice President of International Center for Dispute Resolution of the American Arbitration Association. Miroslava joined the ICDR since 2006. She's very experienced in administering international arbitration and also mediation under various rules of the AAA. Mira, thank you very much for joining us in the morning. Yes, we understand that in your time zone it's early morning, so we highly appreciate this.
Well, thank you, Andre, and thank you to the organizers for testing this conference connection and providing for the secure environment to exchange our thoughts and ideas today.
Thank you very much, Mira. We also have Kevin Nash from Singapore, Deputy Registrar and Central Director at the SIC, Singapore International Arbitration Center. Kevin assists the Register and parties and arbitrators in the administration of cases filed with SIC, and also supervises the SIC's multinational secretariat. So as I understand, Kevin is very busy as always, also in these rather challenging times. Thank you, Kevin, for joining us today. Happy to see you.
Thanks, Andre. Good to see you.
Yeah, and finally, we have Mr. Gary Bourne, President of the SIC Court of Arbitration. Gary Bourne is the partner of Wilmer Hale and the chair of International Arbitration Practice Group of this firm. Gary is the author of the leading books on international arbitration, well, one of which is actually already translated into Russian, and we are just waiting for the opportunity and best chance to officially launch this translation into Russian, which was unfortunately cancelled and was planned within the Russian Arbitration Week, but due to this COVID situation and challenges, so it was cancelled. So we already experienced some challenges, and we already start discussing this. Thank you very much, Gary, for joining us. I don't know where you are, but I'm sure in some safe place, hopefully.
I'm home in London. Thank you very much, Andre. It's great to see everyone again.
Yeah, happy to see you. Welcome. Thank you very much. And finally, a few words about the moderator. My name is Andrei Gorlenko. I'm the president of the board of the Russian Arbitration Center and the partner at Ivanian and Partners law firm, member of the international practice group of the firm. Well, although the name of our session is about challenges and changes, frankly speaking, I think that we are already rather tired of challenges during the last months. So I suggest to speak more about changes today, of course, subject to the speaker's views. I expected that we will be meeting these days in Edinburgh for the ICA Congress, and then shortly at the St. Petersburg International Legal Forum in St. Petersburg. But situation changed, and I also, when I was preparing for this session, I thought that for the St. Petersburg Legal Forum in autumn, we were preparing the session of the arbitral institutions that we want to be a kind of traditional session, and we were thinking of having the topic of this session as arbitration institutions 2030. So to speak about arbitration institutions in 10 years. So we didn't know anything at that time, what will happen, but so we wanted to make these predictions to speak about the future. But frankly speaking, I think all this situation a little bit brought us back down to earth. So just showing that maybe it's too ambitious to speak about 2030, and we shall speak about something closer and see how we'll live and work the closer perspective. So maybe let's speak about some more close future today and some changes that arbitral institutions, arbitrators and parties can expect in the nearest time following this situation and in this, like it said, new normal reality that we have. We will have a kind of live discussion. So there will be no specific reports or presentations during our session. And I would like to start maybe with a little bit provocative question, because actually what I see from my perspective is that the current crisis made almost everyone digitalize. So even those who were not very fond of new technologies, about some online platforms and some who was rather conservative actually, now was forced to use these new technologies and new platforms and to digitalize. Frankly speaking, it made, I think, some process rather easier to handle. So my question will be whether the parties and arbitrators will need arbitration institutions at all in the future, or maybe following this crisis, we will move back to more ad hoc arbitrations, because using these technologies, the parties will be less in demand of actually administration of arbitration, administering of arbitration. So I would like to give floor maybe to Jackie at first to speak on this, and then I would be happy to have others' views. Thank you.
Thank you very much, Andre, and thank you for this opportunity to bring us all together, albeit virtually. When I heard your introduction and I heard what you said about 2030, it occurred to me, and I don't think it's a novel thought, it may have actually been in the previous panel where I also heard somebody say this. In a way, what this crisis has done is to catapult us into, well, whether you call it 2030 or 2028, I don't know, but it's certainly forced us to consider things slightly sooner than we might have otherwise done. On your specific question, will there still be a need for institutions? I would suggest yes. You would expect me to say that, but I genuinely believe that this is the case, and let me give you some case. in a way, this crisis brings out the best and the worst in people and in processes. I think what we're seeing with arbitrators is that the good arbitrators are thriving. The not so good arbitrators are facing obstacles even more profoundly and are struggling perhaps a bit more than others. I think also with institutions, the institutions that are doing their work well are managing, and are managing especially well. I think it is where there are challenges that there are opportunities, and that it is where the institutions come in. Taking a few steps in turn, I think when it comes to appointments, institutions play a vital role. It depends, of course, a little bit on the rules of the specific institution, but in every institution there is either as default rule or as primary rule, a role for the institution to select and to appoint. And I think what we're seeing now, picking up my point about the good arbitrators who are doing even better, we're getting a good view on who is actually capable of managing the challenges that we are facing. And realistically, no matter how many cases you have as an individual party, I don't think you will ever have the sort of insight that an institution has. We'll come back to some specific items throughout your agenda, but I've been following what is happening, how the crisis is affecting each and every case that we are seeing, whether it is procedurally, how the arbitrators are dealing with it. And I think that wisdom, that wealth of information is something that only the institutions will be able to collect. So I think arbitrator appointments, I see even more a role for tribunals, which arbitrators are just more tech savvy, more creative, but are also robust enough to deal with the challenges that need to be addressed. Tricky cases is another issue I was going to mention. You know, when a case is relatively straightforward with solid counsel on two sides, it sounds appealing to say, let's carve out the institution because we've got good arbitrators and there are no obstacles, so it's not necessary. But the moment that there are tricky cases, the moment where there are potential unbalances, I think it becomes much more important to have an institution involved. I think the role of case management may change a little bit, and certainly by going paperless, there is more room for creativity, but that is not unique to ad hoc arbitration. I think there are jurisdictions where the obstacles of the paper-based arbitration are very big, and Russia, sadly, is an example where a lot of couriers are simply not delivering documents right now. So it's especially important to have an institution who can assist the parties and the arbitrators in making the arbitration work. The rules are a factor, and I know we'll come back to that at the very end of this discussion, so I'm not going to expand on that, but I think that's, again, an example of where the institutions are best placed to see whether there are lessons to be learned from the current crisis. And I'd say finance. In this day and age, it's especially important for the institutions to be monitoring the cases, to make sure that arbitrators are in funds, that payments are made. We're going to be facing insolvencies of parties, and for ad hoc arbitrations, that is going to be even more challenging than it is in institutional settings. So I think it's, in a way, nothing new. I think we're going to see that the good arbitrators, the relatively straightforward cases are going to be handled smoothly enough. But the moment that you face more profound challenges, I think the institutions will come into their own right even more. But maybe my colleagues have very different perspectives.
Thank you very much, Jackie, for this very interesting insight from LCIA. So, colleagues, anyone would like to comment?
Just very briefly, Andre, if I can comment, I think there's the strong argument that arbitral institutions are even more important and necessary today than in pre-pandemic, pre-virtual times. Of course, arbitral institutions continue to provide the benefits of their institutional rules, which have default procedures on a number of issues. They also continue to bring their expertise to the appointment of tribunals, the resolution of challenges, decisions about the costs of the arbitration and the arbitrators' fees. They continue to prod arbitrators who sometimes aren't as timely as one would hope. And I don't think any of that changes in a virtual environment. I think there's a further benefit now, though, in a virtual world that arbitral institutions bring. And it's something you can see from how both SIC and ICSID have addressed the pandemic challenges. ICSID has its case counsel, counsel to a particular arbitration, practice virtual hearings with the parties. We do a similar sort of thing at SIC and provide, therefore, a common platform and also common tools that, although perhaps exist in some ad hoc environments, aren't necessarily as certain and reliable. I think, therefore, the institutional experience that institutions have is even of greater importance in this environment than was historically the case.
Thank you, Gary. I saw that Sarah would like also to comment, and then maybe I would also like to give floor to Patricia because I have a question following Gary's words.
Thanks, Andre. I would agree with Jackie and Gary in that there are many contact points that an arbitral institution has with a given case based on its rules. And those contact points and the need for an institution to make decisions doesn't change because now we're in a world where we're using a lot of digital platforms and we're going virtual. Our cases remain difficult and we have multiple parties, multiple contracts. So those kinds of cases will continue. We'll have cases where the parties want to fast track their cases. So sometimes institutions need to make decisions there. And of course, as Jackie mentioned, the appointments process is very important and that will continue to be the same. At HKIC, if I can share some of what we've seen over the past few months, February, March, we saw a lot of tribunals grappling with many requests for extensions of time and for postponement of hearings. And then we saw a bit of a shift. So we saw things start to change where parties and tribunals, instead of postponing, started to go virtual, partially or fully. And over the last 2 months, well, April and May, 80% of our hearings are partially or fully virtual. And just to give you a sense of the model at HKIC, we run a full hearing facility. So we're not divided, we run our cases as well as a hearing facility. So that means that our arbitration team also helps parties and tribunals set up their virtual hearings. And what we've seen is there is a huge demand for guidance because you have a situation where parties are, they're in dispute. So they're not necessarily agreeing on everything. And we have cases where one party will approach us about certain virtual arrangements and will specifically ask us not to mention what they're thinking to the other party. Now that makes things extremely difficult to organize because if you are going virtual, there are many different issues that you need to navigate. And there needs to be early communication and there needs to be a lot of testing very early on. Not only is there communication sometimes difficulties between the parties, but also with the tribunal. And so we have found that we've been called upon very much to be that center point of communications and to help navigate the parties through the various issues that they're going to face. And I think, as Gary mentioned, that is one example where institutions are more and more necessary because, of course, we have such a special vantage point where we see multiple cases, we see all kinds of procedural issues that come up, and we see how they're dealt with. And so we can share that wisdom, we share that experience with parties and tribunals. And singular tribunals do not have that vantage point.
Thank you very much, Sarah. Yes, I think it's very interesting also thoughts, and I agree with you that when one can think about it, it might seem a little bit very easy to arrange everything. But indeed, I think you are completely right that maybe arranging this virtual hearing takes even more time and more nerves and than arranging the normal hearings. And I think that's something that we also noted, everyone working from home, that we started working much more than working from the office. So it looks like it's even more work now for the arbitral institutions. Returning to the issue of the online platforms and some solutions that arbitral institutions have, I would like to address Patricia because, as I know, SEC has a special platform, and recently they announced that it will be somehow shared for the ad hoc arbitrations also. So I think it's rather interesting to hear about this also, and to learn also about the perspective from the SEC from Sweden.
Thank you. Indeed, the SEC launched its platform already in the fall. So this was something which was really long before anyone could anticipate the situation that we're in today. And I think that it was a natural evolution that an arbitral institute, particularly one that likes to innovate, would be moving over to this type of a platform. And it's certainly something I think that we can anticipate other institutes, they're already actively developing, or they will soon be developing and launching these. And they're particularly well suited to have this communication document management platform if one is in a virtual hearing. It makes a nice companion to a virtual hearing environment. The platform that the SEC developed is by design, one that is relatively simple to use. It's a pretty basic platform. It doesn't require a lot of technical savvy. And the basis of the platform is one that many law firms are already using internally for management of case files and things. And it's an opt-in. The communications from the SEC after the request for arbitration has come in and the platform is set up, the SEC will use it for all of its communications to the tribunal and to the parties. But it's optional for the parties in the tribunal if they want to use it. But so far the response has been very, very good. And it's important to note that this platform is for uploading communications, submissions, evidence, procedural orders, etc. It has a calendaring function. It allows for messages that can be seen only by the tribunal or with parties and such different features. But it is not a virtual hearing platform. And parties are free to use any virtual hearing platform for all or some of their case hearings or CMCs or whatever, because that's a separate platform. And I think we're already seeing that hearing centers and other providers are starting to now respond to the existing circumstance and are creating online hearing platforms and administrative assistance, which is very different than what the SEC is offering. It's not offering a virtual hearing platform, but this communication platform. And indeed, it's open to ad hoc. But that does not mean that the administrative services of the Secretariat are offered for free. Those services are offered when parties are using the rules or engage. There's opportunities to engage administrative assistance even in ad hoc cases. And so that having the assistance of the Secretariat is separate. And following up with what Jackie, Gary, and Sarah said, I would like to really emphasize the value added by an institute. And I completely agree that an institute more than ever is going to have an important role to play. And the institute offers not just its services and its rules. I recently heard a webinar. I think that Kevin made the comment in some venue, I heard him speaking, that one of the important strengths of the SEAC is its staff. It's its Secretariat, and that the experience, the creativity, the service-mindedness, the ability of the Secretariat is really the strength. And I'm quite sure that Jackie, Sarah, and indeed the SEC are also full of pride of the competence, qualifications, and the capacity and flexibility of the staffing. And that adds a huge value that you're not going to get if you go ad hoc without administrative services. Even if you try to borrow the rules, which institutes don't like, and try to supplement the decision-making and administrative functions that are in the rules to some other body, you're not going to get the Secretariat and the staffing, which I think is key. And I think when Sarah pointed out, there's a lot of user contact and a lot of perspectives from all the experience that the institute has brought to it. And there's also, importantly, contact between institutes. We saw that recently with the joint statement that I think it was 13 different institutes, SEAC, SEC, LCIA, Hong Kong, all joined in making this joint statement. There was some joint statements made between some of the institutes in response to sanctions a few years ago and sharing of information. So there's a lot of important information sharing and also standard setting and best practice setting between the collective dialogue going on between the institutes. So I see institutes as important leaders, innovators, and shepherds of the arbitral processes. And more than ever, that type of leadership and innovation and hands-on shepherding of the process is needed.
Thank you very much, Patricia. I think Jackie wanted to comment here briefly. Yeah.
Briefly before handing over to Mira, I just wanted to pick up the point that Patricia made. Indeed, I mean, as important as the virtual platforms are, I think it is the core of what the institutions do is case management, which can for some include providing the platform. And that's where, you know, especially in times of crisis, the institutions have such an important role. I'm thinking of arbitrators who call up and say, you know, what do we do about not just the technicalities of virtual hearings, but is it okay for us to do virtual hearings? And you can discuss with them. Of course, you don't decide the cases for them, but you can discuss, yes, there are other cases that are going virtual. These are providers, these are considerations, or the Secretariat may nudge certain arbitrators who might otherwise be inclined simply to suspend because there's a pandemic out there where you say, well, you know, this may be time to give them a call and say, do you really want to do that? I mean, there may be reasons why a particular case should be suspended, but I think it really plays to the strength and the weaknesses, which is why ultimately I think this crisis is going to show that the robust institutions will do even better because they offer the services that users need. Thanks.
Thank you very much, Patricia. Thank you, Jackie. So I see that Mira would like to take the floor.
Yes, thank you, Andre. And I'm going to make it unanimous case, supporting everything that's been said. Obviously, the question is, can the institutional arbitration continue to present a better alternative to self-administration during this crisis? And as we've heard, there were points on values with respect to case management expertise and the teams with respect to finances. I would like to make an additional point and start with the question, what does digitalized mean for arbitral institutions? Are we digital migrants or are we digital native? I think many of you would agree that with the years of experience being long-established institutions, we were not born with digital identity, but we adopted technology-first approach as we were developing. At the AAA ICDR in 2013, we did launch our own first cloud-based case management platform. And the platform allows case management staff as well as parties and arbitrators to use technology. And technology does save time. Time is money. So in a way, we can look at ourselves and say, we're still operational. We all went working remotely. We provided platforms for the parties to file a case online, to pay filing fee online, to access panels online, to strike and rank arbitrators since the ICDR is using list method. And it also could be done online. And the final point, if you look at typical AAA ICDR case, technology assists throughout the process at initial stages. Filing and initiation online, conference with administrator telephonically, selection of the arbitrator online by email, preparatory conference, very frequently it's done telephonically. It's not like we've been changing our operations drastically, but obviously we're very mindful of the impact of the pandemic on the way how we operate. So again, making this as a point to bring the value to the dispute resolution, you have to be well positioned, and I think institutions are really well positioned to do so, even during the pandemic. Back to you, Andre.
Thank you very much, Mira. And if I'm not mistaken, one of the speakers of our first session of our conference, I would say grateful speaker, was also saying that about 8 years ago already, or maybe 6 years ago, he used your online platform, and it was very convenient. So that's how actually you have the feedback also from another session and other speakers. Now giving the floor to Kevin, I would like to ask your views on this, and well, whether you feel and your colleagues feel yourself as very confident shepherds now.
Andre, I will make it unanimous and echo the comments of all the panelists. The general tenor of party choice in arbitration was already quite overwhelmingly in favor of institutional arbitration, but it's more important than ever now to have that institutional oversight and institutional discretion. It is a bit blue ocean to a certain degree. I would say when you're looking at the case management at SIC, we have never been busier, but more importantly, we've never had more contact with parties and arbitrators. There's a lot of unique situations that are coming up where you really do need that institutional oversight. In addition to being very busy and having a spike of cases, we're also seeing more applications to the institution because of the cost sensitivity of parties and the urgency of certain disputes. You're seeing more applications for expedited procedure because you may not be able to access a court. We're certainly seeing more applications for the appointment of an emergency arbitrator. I think that we have 3 ongoing right now. There's very practical matters as well. Parties may not be able to pay the deposits towards the cost of arbitration, and they may have a very legitimate reason to request an extension. I think Jackie made a very good point when she was talking about ad hoc arbitration being all very well, and arbitrations generally being very well when you have cooperative counsel on both sides and an experienced tribunal. Where the institutions are very important is where there might be a lacuna. So if you're looking at being able to provide guidance to the parties, I think one of the most important things that institutions are doing right now is dealing with the notification of the award. So whether it's prompting the tribunal on circulating signature pages, it perhaps advising on signing and counterpart, looking at the jurisdiction and seeing whether there's a wet ink requirement in that jurisdiction. We are going to provide the physical notification of the award in any event, but these are all things that you don't get in ad hoc arbitration, that you do get in institutional arbitration. Even better, because there are so many new situations, in addition to the joint statement that Patricia mentioned, is that the institutions really are working more and more closely together, because with all of these new institutions, we're taking the wide body of institutional knowledge. The institutions are sharing more, and this is all an additional value add for the users.
Thank you very much, Kevin. Unless there are any other comments, does anyone would like to take the floor? Then, yeah.
Andre, just a quick note, since I was, if I may, since I was talking about technology, you know what I forgot to mention? Cybersecurity goes hand in hand with technology, and institutions are really well positioned to raise these questions with the parties and arbitrator. Obviously, here at the ICDR, what we've noticed, our webpage has designation secure case administration. So many clicks. We definitely understand that the parties are interested, that the technology would not somehow interfere with the privacy of case data, personal data, and there's a means that institutions have to ensure that the safeguards, proper safeguards in place. So we can talk about cybersecurity later, but I thought I would bring it as an additional point in support of administration, because that's not a something that you would expect in ad hoc arbitration would be well thought or discussed during the arbitration?
Thank you very much, Mira. So I also see that Patricia raised the question internally, saying that well, there is also difference sometimes between institutional and ad hoc arbitration, because in some courts and some jurisdictions, institutional award have a stronger position than ad hoc. Indeed, for example, I think that's the case for some categories of disputes in Russia, for example, where a certain type of disputes, like corporate disputes, can be heard only within institutional arbitration, not ad hoc arbitration. So I think that's also important to bear in mind when we speak about the differences, yes, and advantages and disadvantages. I also see that we have some questions, and I would like to remind, before moving to another topic, that we are having some questions from the audience, and the audience can ask questions. I see already that we have not a question, but a comment, and I would like to share it with the speakers and the audience. So we have a comment that there is another example of what institutions can do. At the height of the COVID crisis in Milano, in the Chamber of Arbitration of Milano, CAM, the chamber stepped in and decided to suspend all procedural time limits, to cancel all hearings and pending arbitrations for a certain period in order to safeguard due process. This would not happen in an ad hoc arbitration where the tribunal becomes inoperative due to a health emergency. So this also interesting I think example from Italy. So if someone would like to comment on this, I think that's rather interesting. I suggest then that we move to another topic now, so I would like to discuss the 5 E's that were introduced by Gary Bourne, which is, if I may, Gary, they are that arbitration is more efficient, more expeditious, more expert, more even-handed, and more enforceable. So my question is whether we will need to revise these 5 E's of arbitration after this crisis, and whether we shall need some additional maybe E's, like, I don't know, economy, for example, echoing to what Jackie said about potential financial problems, some insolvencies, or maybe not even E's, but some other capital letters will join these 5 E's. So Gary, if you would like, please take the floor.
Thank you very much, Andre. I always like to take credit for things, but unfortunately I can't take credit for the 5 E's. They've been there for the last couple thousand years, and they were invented by all the thoughtful commercial users of arbitration. They were the reasons that people have consistently over the past centuries chosen to arbitrate. I do think, though, that with this current crisis, arbitration can continue to demonstrate the flexibility and adaptability that historically gave rise to the 5 E's. I do think it's important that we continue with E's as opposed to other letters of whatever alphabet, Cyrillic or otherwise, one might choose to use. I think a 6th E actually can be electronic. More than national courts, international arbitration can be more electronic than domestic court proceedings by making use of the various platforms that are available, whether it's Zoom or WebEx, BlueJeans, something else. I think it's essential that, as tribunals and institutions already have been doing, we make better use of the available technology than national courts. I've, at SIC, had a number of Zoom conferences with our Users Council around the world. I've got one with the Users Council in Russia coming up early next week, in fact. And what we've heard in these User Council meetings, virtual meetings, is that in national courts in a number of jurisdictions, proceedings have really ground to a halt. Judges are either unable or unwilling to use technology to conduct hearings, at least many types of hearings, in some cases all types of hearings. Some national courts are, of course, exceptions to that. Courts in some jurisdictions are using virtual technology. again, at least for some types of proceedings. But I think the response thus far of the arbitral community has really been on the cutting edge of technology. As other speakers have mentioned, arbitral tribunals continue to conduct hearings, sometimes over the objections of one party. You can watch some of those hearings live online. ICSID conducted a full evidentiary hearing not too long ago. At SIC, we, and I'm sure at other institutions, are seeing exactly the same thing. And so I do think that it is both correct thus far to say that arbitration is proving more electronic than the alternatives. But I also think it's important to remember that this is a challenge and an opportunity. We need to continue to push our game, in a sense, to step up to both the challenge and the opportunity of virtual hearings, to make sure that we do what it is that parties have reposed the confidence in us to do, namely resolve their disputes efficiently and expeditiously.
Thank you very much, Gary, for this. So we now at least have one new E. Yes, that's really interesting. Okay, so who would like to take the floor? Maybe Sarah.
Thanks, Andre. Yes, in terms of the 5 E's, I think it's pretty clear that if we are going virtual more and more, then we're going to be enhancing a lot of them. So for example, efficiency, because more people are being forced to digitalize and to become familiar with these systems, going forward, I think people will be much more comfortable using them in a much more normalized, much more frequent way. And so we will become more efficient. I think that's pretty obvious to everyone. In terms of cost efficiency, we did a calculation today. Actually, we have a fully virtual hearing, and we calculated how much it would have cost if it was a normal in-person hearing. And in terms of the costs just related to the travel, accommodation, and the room hire, it would have cost about 400,000 Hong Kong dollars. So that's about 40,000 roughly US dollars. And then when we compared it to what it cost because it was virtual, it was less than half. So there's a significant saving, and we know that parties are so concerned about cost efficiency. So I think that's going to be really compelling going forward. In terms of expeditious, because we're now more and more online, it's going to be much easier to combine the availabilities of arbitrators all over the world. It's much easier to turn up for a call like this. Here we have people from Asia, Europe, the US, all coming together, than say compared to a 4-day trip with a long haul flight both ends. That's obvious. In terms of expertise, I think that what will be demanded of arbitrators and of counsel is expertise in terms of becoming digitally literate, at a very high level. And I think there will be less patience for people who just can't deal with WebEx or can't deal with Zoom. I mean, that has to move into the past. So there will be a lot of room for new skills. I think the legal expertise will remain more or less the same. Even-handedness, I think that this new age brings into play questions about the equal treatment of parties. If you have one party, for example, that can only present their witness virtually, can only make their submissions virtually, whereas the other party can appear in person, does that lead to the unequal treatment of parties, which then leads on to the next E, which is enforceability? Does that somehow jeopardize the enforceability of an award? And we have to think a little bit about the jurisdictions where enforcement is going to take place. There are some jurisdictions where online dispute resolution is mature, others where it's absolutely not. So that's going to play into it as well. I agree with Gary completely that the final E, or the added E, is electronic, and I think it's just E. And I think arbitration as a process is often the process that will lead dispute resolution more generally, will lead courts, because we are more flexible. The participants in an arbitration are private individuals. We're not a domestic court system or a domestic court, which may be completely reliant on documents and not have any kind of digital or virtual being. So yes, I think that now there may be 6 E's.
Thank you very much, Sarah. I see that Jackie would like to speak.
Yeah, I'd like to supplement these very helpful comments. And I think picking up the point of the courts, I think we're going to look at a very interesting relationship between arbitration and court, because it is, of course, very true that in arbitration, we have certain advantages that in many courts we don't have. At the same time, I see, again, here an opportunity in the sense that some courts are moving ahead at full speed as well. And I think that is actually also in the interest of arbitration. We did an LCIA seminar earlier this week where we discussed, what is happening in these cases where parties are moving to virtual hearings and where arbitrators are ordering virtual hearings, even if one of the parties is not consenting. And I think you're going to see a shift or a divide. In some jurisdictions, this will work, in others, it may not work. But if you end up in a court where the courts themselves are doing virtual hearings, I think it is obvious that your position will be a little bit different than if you are in a court where everything done is based on paper and in a very old-fashioned way. So I think it's another opportunity not only to look at which institutions and which arbitrations and which arbitrators are best suited to the job, but also which jurisdictions are going to be supportive of arbitration. And I must say, I am impressed how some courts are moving ahead in the same way that we've been catapulted into 2030 in arbitration. The changes in the courts are also phenomenal and very different in different jurisdictions. There are legal differences, but there are also practical differences where some courts pretend to do a lot and don't, and actually others are much more flexible than you might think. So I think it is worth your while as a user properly to explore what is available.
Thank you very much, Jackie. Before giving the floor to Patricia, I would like to also comment on this and about the difference and the situation with the courts, because I think in Russia we had the situation for a rather long time that our state courts, specifically commercial state courts, were rather digitalized. And actually, I think this was one of the drivers that made, for example, us at the Russian Arbitration Center to develop our electronic online system from the beginning, because we understood that we shall provide the same quality of digital services, and to give the opportunity to provide parties with such kind of online platform. And we see now that Russian courts are now also introducing some online platforms for the hearings. At least Supreme Court, they're starting to do it. So, and I think it's also kind of good trend, and also for arbitration, because it also makes possible to enforce arbitral awards. So it's generally good for the arbitration too. And I also would like to raise one more issue. Maybe someone would like to comment that indeed maybe this crisis would lead to some legislative changes in some jurisdictions to make some I think barriers for more efficient arbitration, where in those jurisdictions where such kind of legislative restrictions are, where it's not possible, for example, to conduct online hearings or something, some other maybe restrictions. So maybe it will be also kind of driver to have these changes. So now I would like to give the floor to Patricia.
Thank you. A couple of quick comments, and let me follow up. I had the pleasure of learning how to make Russian salad from Vladimir Kovalay a couple of weeks ago. And I posed a question on the chat, which he answered. And the question was just that, how courts in Russia might respond to an award which was a result of a hearing being held where at least some of the logistics, if not the very fact of the virtual hearing, had been objected to by one party. And Vladimir was of the opinion that the Russian courts have become extremely familiar with using digital solutions, and he ventured the opinion that he thought that the courts would be sympathetic to the situation, and as long as it was handled in an even-handed, one of Gary's E's manner, and ensuring equal treatment and the right to be heard, that it would not be a problem. So I think we're seeing that courts who do not take a modern approach now are really going to be seen, as Jackie mentioned, the foot draggers, and it's not going to be, or maybe it was Sarah, it's not going to become a good selling point as a place of arbitration if the courts are not receptive to the realities of the current situation. But I wanted to make a point that has been made by many people, not the least by Mike McElrath quite a lot, and that is we need to recognize that this virtual platform is different. It's not better, it's not worse, it's different, and we should not try to simply mimic or replicate a live hearing into the virtual platform. And as was pointed out by Jackie and others, it's really important that there's planning, that there's consideration for a number of things to enhance this particular medium. Be aware of what it offers and be aware of what might be sacrificed and how to make up for that. And no, one thing I think that we all recognize is that in this kind of a platform, one gets tired more quickly, and particularly if you have arbitrators, counsel, and witnesses who are spanning the globe in different timeframes, you just can't keep the same kind of schedule. And you need to have breaks, and during the breaks in the live scenario, counsel have opportunities to talk to their parties, and they have opportunities to talk to the other counsel. There may be greater opportunities for trying to see whether or not some issues could be settled or the entire case be settled. This environment creates a need to try to keep that connectedness, not just within the team, but with all the players to the arbitration. So these are part of the challenges that Gary mentioned, which also will become opportunities. And not the least, I think all of us will be embracing these digital solutions. It's sure a lot easier for me to instead of going to town, to simply go down the stairs to my downstairs office and close the door, and then go back upstairs again when it's over. On the other hand, I think all of us would agree, wouldn't we love when this seminar is over that we could mingle with all the participants and chat with each other over a coffee or a glass of wine?
Yes, thank you. Well, we can make, I think, a separate Zoom chat to have a glass of wine and after the session all together. Thanks God it's Friday. Thank you very much, Patricia. So, Kevin, would you like to comment?
Let me see if I can tackle two of the E's, and I'll start with the 6th E, electronic. And I think Patricia's point is very important. Is the question that we're trying to replicate in-person hearings electronically, or as one of the other E's, can we find more efficiencies? Do you need this many days of hearing? Do you need this much witness evidence? Will parties be more inclined to agree on the documents? And even though this is a new, potentially 6th E, arbitration has been preparing for this for years. I think all of the institutions have facets of their case management that involves a lot of electronic platforms. So you have institutions with online case filing. Every institution has an automated electronic case management system. This is the reason why all the institutions are able to work remotely and very seamlessly, because we have these internal electronic case management systems. You have document management, either incorporated within the institutional structure, or parties are free to agree on external electronic document management. And then ultimately you have the e-hearings. So it's a question of taking some of these best practices and then maybe re-looking at the practices that gives you that E for efficiency. On enforceability, in addition to the enforceability under the New York Convention, just to touch on the previous audience question on, is there a difference in enforceability between ad hoc proceedings and institutional proceedings? SIC has a formal scrutiny process. This is what we spend most of our time on, is the review of awards before they're transmitted. But even institutions that do not have a scrutiny process, all the institutions are looking at the award to make sure that they comply with the local requirements of where these awards might be going. There's also the confidence that you have in the enforcement courts. if a court is used to seeing awards from a certain institution, there is that degree of confidence in the courts that these are enforceable awards, these arbitrations have been well managed. So I think that there is a difference with awards that are transmitted and emanate from the institutions.
Thank you very much, Kevin, for this very interesting comment. Mira, would you like to take the floor?
Yes, thank you very much. Not to repeat again what's been said about virtual hearing and adding another electronic, I do want to, again, kind of bring our attention to the institutional perspective of bringing value to these electronic case processes. At the ICDR, we are working with the arbitrators and providing them with information as well as training in terms of handling virtual hearing. Probably as many other institutions, we issue a model order on conducting virtual hearings because there are many procedural questions that you as an arbitrator as well as the participants would like to discuss in advance of this innovative approach to the hearing. And yes, discussions could be in line and the parties will reach agreement. Sometimes there is expertise of arbitrators needed to resolve this type of situations. On top of that, at the ICDR, we don't have our own platform for virtual hearing. We using Zoom platform and looking at other platforms suitabilities as well, but at no cost we are offering to host virtual hearing. And we haven't had one, but we already have test trials or virtual hearings conducted this week. And we're ready to have those hearings next week. So, you know, if we're going to have another conference, I'll report you on how it went. But using this opportunity, I'd like to kind of shift gears and also add an additional point to pragmatic reasons to select arbitration. And we've talked about this many times, but I thought it's still a good opportunity to remind all users as well as institutions that diversity still matters. Business organizations, even in this challenging times, they do not discount diversity, and it translates to all operational activities in the business, including maybe unwanted one of dispute resolution mechanism, and being able to deliver on the demand for diversity from the organizations is important. I don't want to break that elegant structure of E's, and maybe diversity could not be added as D, but if we look at it as equal representation, it will be another E to present to your clients in support of you demand diversity in your business, and you can demand diversity in a decision maker and select from a diverse panel of the arbitrators that provided by the institutions. So with this said, it's not obviously something that is relevant to the current pandemic, but I thought it's a nice opportunity while we're all speaking here to voice it as an additional point for arbitration.
Thank you very much, Mira. I fully agree. And I think even if we put D, so it's rather close to E in the alphabet, so it works pretty well. So I fully support this idea. So then, unless there are any other comments, I would like to move to another set of questions that I would suggest to discuss. As arbitral institution, as generally arbitration, we exist to respond to the demands of the users of the economy. And I think we hear a lot of voices now saying that the structure of the economy will change even faster now to maybe more high-tech companies, new high technologies. We experience these with all these platforms also emerging now. So what type of disputes we expect in the new world after the crisis? So for sure, we're not expecting them, I think, in 1 or 2 months, because in arbitration world, we experience some period of time between arbitration clauses are included in the contracts and then the disputes arise. But I think we shall already start thinking about it, whether we shall develop some special IT high-tech panels of arbitrators, whether we need some, I don't know, new type of arbitrators maybe, and we shall educate them somehow. So I would like to hear your views on this set of questions, and maybe Patricia, maybe you take the floor on this.
Thank you. Well, I think that as regards what types of disputes we can anticipate are going to be coming up as a result of the current situation, it would actually be a much shorter list if we said, what do we not expect to increase? Because I think we're going to see disputes arising out of every type of sector. There are very few sectors, apart from perhaps those who are selling technological solutions and platforms, which are being really seriously adversely affected. So certainly the construction and the infrastructure projects are having an impact, which not in the least involves financing matters. We have interruption of supply chain, which is affecting, of course, supply of goods contracts. We have going to be having, obviously, later today, there's going to be a special presentation by on force majeure by Klaus Petterberger. We're going to have insurance issues that are coming up and reinsurance. Certainly, we're going to see insolvency meeting arbitration, which we all know creates a lot of interesting and sometimes complex issues. We are going to have issues regarding to certain export bans or restrictions. Certainly, there's going to be issues that are coming out of state support to various industries and the state's reactions to what is going on that could generate investment disputes. Many are predicting that we're going to see an increase in third-party funding. And I think that already institutes are seeing, I think that one of the speakers has already mentioned. Huh? Yes, I heard someone speaking.
I heard that we have some, I think, tech problem maybe, so then we need to have a kind of 5 or 10 minutes break. Technical, excuse me, please. So I was told by the organizers, so excuse me. Okay. So can we put it on hold?
Sure.
Yeah, thank you, excuse me. Let me check.
Okay. Should I continue, Andre?
Yeah, please excuse everyone for some technical problems, but it happens in this new normal reality. So we're back.
Well, it's not the problems that occurs. Where you win is showing how adaptable you are and how you can seamlessly deal with the problems. And that's what we're doing. So going back, I think the last thing I mentioned was the state's necessary responses to the current virus health situation and the economic situation as a consequence, of course, are causing a lot of very quick moving measures, which could end up generating a number of disputes that are coming up, and we will probably also be seeing the increase in third-party funding for insolvent parties that may have claims. And during our break, we were discussing a bit, and I was inquiring if the institutes are seeing more requests for intermeasures, more emergency arbitration applications. There may have been immediate fall off in filings as parties adjusted to this, but perhaps many are now scurrying to try to get a filing in before the situation becomes more dire. And also I've heard rumors, and I've heard in some different contexts, that settlement discussions seem to be going on because many parties, particularly if they're in a long-term performance contract of different sorts, realize it's to their advantage to ensure that they don't use the current breakdown as a way to break the back of the other party and to end up breaking the continuing relationship, so that they see it that it's in their advantage to try to find some kind of collaborative way to work this out so that they can continue the project of performance. So it'll be interesting to hear from all of you if you're seeing more settlements, if there's a greater interest in mediation, if your cases are dropping off or spiking. So with that, I'm back to the panel.
Thank you very much, Patricia. And I think indeed, I think it's very important and maybe encouraging that if the settlements grow, because I think for the whole economy, it also may be rather important, rather to continue relations and to make the economy flow further rather than go into disputes and breaking these ties, yes, and some connections. Maybe who would like to comment? Maybe Kevin, you would like to share experience of Singapore, also your special ARB-Med-ARB provisions, so how it works. But
sure.
Mediation is more popular.
Starting with the types of disputes, as Patricia says, I think that you're going to have disputes coming from a broad range of categories. One interesting observation that we have from SIC is that the time from contracting to dispute seems to be abridged. We are actually getting cases from relatively new contracts that are arising directly out of COVID-19 that may be going to dispute really in a matter of months. So I think that's going to continue because if you look at it from a party perspective, if you're drafting a dispute resolution clause right now in an international contract, you're likely choosing arbitration and you're likely choosing one of the major institutions that's represented here tonight. So we're already getting a spike in cases, applications for emergency interim relief, expedited procedure, and it looks like after we come out of this that there are going to be even more cases. We were discussing during the break the possibility of ARB-Med-ARB and whether or not you can apply for ARB-Med-ARB post-dispute. I think that's one thing that we're seeing as well. Not always is that parties are talking more. So SIC has a link up with the Singapore International Mediation Center, whereby you can start arbitration, stay the arbitration, go to mediation, and if you come to a mediated agreement, you can go back to the tribunal, have it given effect in a consent award, or if you're not able to reach an agreement in the mediation, then you have a standing tribunal up and ready to go. It's hard to say whether or not there is more settlement, but I do think that parties are talking more. They're getting a bit more creative. So the idea of mediation, maybe in the previous normal, might not have made sense in a certain type of dispute, but now in this new environment, it does make sense. There's a chance of saving all sorts of time and all sorts of costs. So you're seeing parties starting to explore different possibilities, ARB-Med-ARB being one of those very good possibilities.
Thank you, Kevin. And maybe also this situation will lead to more countries joining the Singapore Convention on Mediation. So maybe it will also be a driver here. Does anyone would like to comment also? Jackie, please.
Yeah, I'm very happy to comment on a couple of points. On the mediation and settlement front, I hear a lot about that anecdotally. So far, our numbers don't really show a spike in settlements or a spike in cases moving more towards mediation or more mediations coming in. But that ties into the pipeline point I was going to address. In general, we've seen an incredible spike in cases, but I think here we need to take into consideration where different jurisdictions are in the sort of pandemic development. What we are not yet seeing is cases triggered by the crisis so much. And I have a hunch that the cases we've been seeing are cases that for a large part were in the pipeline before the crisis really took effect. And now all the law firms are set up virtually, the clients are set up virtually. I think we're still seeing a bit of a transition where in order to file a case, you obviously need to have a seamless interface between the client and the law firms. And I think as the crisis continues, it becomes inevitable that you have to set that up. Whereas initially people may have thought, well, we'll wait it out. That's not an option. So I think we're going to be seeing new cases. So first of all, the spike in cases we've seen, interestingly, was not even yet COVID related. And I do anticipate we will see even more cases, certainly medium term. But I expect a little bit of a dip potentially where people are trying to make this new normal work. The other comment I was going to make is something you asked, Andre, at the outset. Does this situation call for different arbitrators? And I'd like to pick up a point I raised myself at the very outset. I think what we need is more good arbitrators. And I don't think we necessarily need only younger or only older arbitrators. I think there are some older arbitrators who are really good at coping with the current situation, who have actually been at the forefront of using the technologies that are available. There's so many platforms out there, and there's so many document systems out there. And some arbitrators have been prolific users of these systems for quite a long time. We're also now seeing some younger arbitrators who indeed have the sort of tech savviness that may give them a bit of a boost and hopefully will enhance diversity in that sense. So I don't think it's going to be a one-dimensional development. I don't think this means that we will have only younger arbitrators who are more tech savvy, but I do think it is a bit of an opportunity. But equally, I also think it is a good opportunity for the better, more senior arbitrators to stand out even more. And I think that's what we're seeing where parties are selecting arbitrators. It is interesting to see that they are selecting some of the usual suspects, but not all. So clearly there is a bit of a shift going on where it is known that some, I think, are better equipped, are better adept at dealing with the current technological challenges, and who also show the robustness which this situation requires.
Thank you very much, Jackie. I see that Mira would like to comment.
Yes, to pick up on Jackie's point on the type of arbitrators and to share some observations. Obviously, some arbitrators are more ready for new virtual reality than others, but those who are ready or being in the process of getting ready, we've noticed resumes of arbitrators started reflecting this specific keywords, meaning I want to be signaling to the parties, to the users that I can do it. Although, again, as we talked before, institution can always help with the virtual hearing as needed. And back to your original, part of your original question on high-tech arbitrators. Obviously, the more you use technology, the more it might be expected that the technology disputes will be coming up. And that's not something new. Technology disputes been around for quite a while. And in response to that environment, the band ICDR, AAA put in place the specialized technology panel of arbitrators, obviously understanding that knowledge in a technology dispute is crucial, because what is at stake, we have about 400 arbitrators and mediators, their attorneys, former judges, business experts as well. I don't have full data for 2019, but for the 18, we conducted 380 tech cases, and the range of claims is pretty impressive, from $20,000 to $57 million. And in 2019, we got a case for $327 million. So you see that it's large, complex cases, not just by value, but because of the knowledge in a specific industry. So what type of disputes? There were software, system development, partnership, joint ventures, licensing, and a representative sample of cases shows that the parties were from US, Canada, Hong Kong, Japan, Korea, Australia. So you see the international nature of that caseload. The cases were seated primarily in the US, with focus locations in New York and California. And again, going back to settlements, only 1/3 of these cases went to award. 2/3 settled prior to the hearing, and 28% of the entire settled cases didn't incur any arbitrator fees. So again, it's something that you would think as a user, when you do your cost business analysis, your return on investment analysis, you look at all of this and you make your decision whether to go to arbitration or not. And I think that's an important point. Now, just procedural highlights. For institutions dealing with these cases, we help the parties through the pre-screening mechanisms that we have in place. Because in addition to being a good arbitrator, meaning, or great arbitrator, meaning schooled in both in the science and art of the procedures, parties wanted to have a very unique technical expertise. For instance, 3D printing or software, hardware engineering. So, you know, this an interesting combination of parties' request for these arbitrators made us feel that we would be helpful in doing pre-screening. And we also give the parties full access to our panels in the our typical approach, letting parties have an opportunity to try to agree on a suitable arbitrator. And again, among 400 arbitrators and mediators, the hope you would find one. So with this said, I just go back to you, Andre.
Thank you very much, Mira. I think rather impressive statistics, thank you, from AAA ICDR. I would like to give floor to Sarah, because as far as I remember, HKIC has its IP panel of arbitrators for some quite of time. So what are your thoughts from Hong Kong on this?
Yeah, I think that it makes sense. I mean, we've got an IP specialist dispute panel of arbitrators. We also have a financial services dispute panel, and that's been useful for parties, both of those lists. And I think that a technological-based list could be useful as well. So I think that makes sense. And, you know, it's really what motivates the institution is what is useful for users. So if something's going to be helpful, we say yes.
Thank you very much, Sarah. I would like now to turn to Gary. Well, I think you are one of the most experienced arbitrators in the world. So I would like to ask you, so what type of arbitrators we will need actually in the future, or maybe there will be no changes, and actually were well prepared already before the crisis, and maybe also about the disputes.
I agree with most of what's already been said. I think we're going to see a wide range of disputes. Obviously, the pandemic, because of the economic dislocation, is going to accelerate the process of parties coming into dispute. I think that will contribute to a continued spike in arbitrations that are filed. I think issues arise as to the ability of parties, the desire of parties to follow through on those proceedings. I think sectors where it's particularly likely in current circumstances to see disputes revolve around the energy sector. I think what's been happening with oil and gas prices, whether it's in the context of price review or how one develops an onshore or offshore block is really an area where we'll see lots of disputes. In terms of the types of arbitrators, perhaps it's because I'm so young, but I disagree with Jackie a little bit about the kinds of arbitrators that are best suited. I think we really will see an introduction of more interest in the young guard. I think we are inevitably more tech savvy, more willing to push the boundaries with new technology. And I therefore think for all of you younger viewers, this will be an enhanced opportunity for you to serve as arbitrator. I think that's particularly true because at SIC, we're seeing a greater number of emergency arbitrations and expedited procedures involving smaller value disputes where I think young arbitrators are especially well suited.
Thank you very much, Gary, for this. Unless someone, yeah, sure, Patricia would like to make a comment, I see, yeah, please.
Yeah, two quick points. One, I think we should make a distinction between arbitrators who can manage technology in terms of dealing with heavy data encrypted hyperlinks and dealing with virtual hearing platforms and dealing with online platforms. And actually most of these kinds of technology are made for dummies. They're pretty like this. Zoom doesn't require much effort to learn how to operate. So a lot of it has to do more with a little bit of common sense about planning and running a project and anticipating, and there's lots of protocols and things out there. So I think that's different from saying that you might want to have an arbitrator who has particular knowledge about technology issues and the law that relates to various technology issues, whether it be intellectual property or whatever. So you can be a generalist or someone who's quite good at, say, the CISG law or whatever, and be very competent to use the technical tools, but not be particularly well suited to be doing a highly technical dispute about advanced aeronautics or something. So I think we need to make a difference there. And it could be then an opportunity, as Gary pointed out, for younger people, particularly in the role of a secretary. There's lots of discussions, look at the LCA rules and others, about not delegating too much to the secretary. This could be a great opportunity if arbitrators who are not so comfortable with arranging the technology to be able to rely upon a younger secretary who can help them go through all the protocols, plan the agendas, and to hook up and to make sure everything is working properly.
Thank you very much, Patricia. It's indeed very interesting comments. I think Jackie would like to comment, yes?
Yeah, I don't want to disappoint Gary, but I don't think I disagree with you, Gary. I think I was perhaps a bit unclear in my comments. I was trying to say that I think we're going to see two things. I think we are indeed going to see opportunities for younger arbitrators, whether that is in smaller cases or more generally. I also agree with Patricia's point. We should distinguish between perhaps a specific case, just dealing with the technical sides of handling a case and disputes about technical issues. But what I was saying is that this will actually potentially lead to a shift in the selection amongst the more senior arbitrators, where we're going to see that some float up as the preferred senior arbitrators and others are going to be perhaps less suitable to the new normal, whether that is because of their lack of affinity with some of the virtual demands, or simply because we will be seeing some cases where some robust case management by the arbitrators is necessary, certainly in the big cases. And that's where some gray hair may be very, very welcome and necessary, but it will need to go hand in hand with being comfortable with the new technology that is around us. So I see both for younger and for more senior arbitrators a future, but not for all of them.
Thank you, Jackie. I think this brings us to our final topic of today's discussion. That would be interesting, I think, for the users and also for the arbitrators and for, I think, for arbitrators. Which amendments to the arbitration rules, if any, shall we expect from the arbitral institutions following the crisis? And do we need some joint efforts on this, maybe, in the nearest future? As it was already mentioned, we see that there are some joint protocols, joint efforts in place by the institutions. We also see, I think yesterday it was announced that there are some joint efforts of hearing centers making some alliances, including Maxwell Chambers in Singapore. Whether we expect some changes, whether we shall coordinate somehow here in order to provide the users and the arbitrators with the necessary tools to make these our 5 or 6 E's even more in demand. So maybe Mira, would you like to take the floor?
Sure. Thank you, Andre. Obviously, in the environment of big change, you naturally would want to make a big splash. And in a situation of COVID-19, it's slightly different because addressing the situation from the administrator, in my view, is not an easy thing. There's still tons of uncertainty there, and you just go with these incremental steps. You learn from the cases, ongoing cases. You learn from changing regulations, and then you look at how, as an institution, you can reflect this all in the rules. So far, from what we've learned at the ICDR, by looking at the ongoing cases, the rules work. We just, by example, one of the articles, Article 17, place of arbitration, being used a lot in virtual hearings, and the article provides that the tribunal may meet at any place it deems appropriate for any purposes, including to conduct hearing, hear witnesses, inspect property, document. And if it's done elsewhere than the place of arbitration, the arbitration shall be deemed to take place in the place of arbitration, and the award shall be deemed made at the place of arbitration. So we'll see that it's being used by tribunals in their virtual hearing orders. Now, Article 20, another highlight, conduct of the proceeding. Tribunal has a duty, and I'm underlining and emphasizing duty, to conduct the proceeding with the view to expedite the resolution of the dispute, and may consider how technology could be used to increase the efficiency and economy of the arbitration. Again, it has been used and referenced a lot in the recent procedural orders from the arbitrators. And the rules do have direct references to online filing through the ICDR AAA platform. It references electronic communication between the parties, issuing notices through electronic means, and include a reference to video conference. So this is not to say we're not looking at perfecting and developing or innovating with respect to the rules. Indeed, understanding that the right rules is foundational to the process of successful arbitration. We've launched the review of our rules, and it's not in connection with the COVID-19. We've launched it way before, and there is a working group that is reviewing our rules, which are answer-trial-based rules and focus on parties-centered processes. But again, so far we learned that rules do not negatively impact what's going on. And if we can add something to the rules, we're still looking. There are discussions going on. And as Russian proverb goes, много говорится, да не все в дело годится, which is to translate, much is said, but not all is actionable. You know, this time we're not making any specific changes. And back to you, Andrei.
Thank you very much, Mira. Gary, would you like to comment from SIC perspective, and maybe Kevin will also comment on
by all means, Andrei, and I comment entirely under the control of Kevin, who is the world's leading expert on these issues. Coincidentally, at SIC, we're literally about to announce, and I think I can do it now at the Russian Arbitration Center for the first announcement of the SIC's revision of its rules, and we'll be seeking comment from users, including our many users in Russia, about what the new rules should say. And I think what our new rules will do with respect to virtual hearings obviously depends on what our users desire. My own view is that many institutional rules, including the SIC rules, already cater pretty well for virtual hearings. They do so by giving the arbitral tribunal broad authority, procedural discretion to conduct the arbitration, not just fairly, but also efficiently. I think that an argument can be made, and I'm sure we'll hear expressions of this view in the rules revision process, that there should be specific reference to virtual hearings. There are some commentators, German ones in particular come to mind, continental Europeans, who take the view that when institutional rules require a hearing, it means the old kind of hearing, the kind of hearing where we were all in one room, and not this kind of hearing, a virtual hearing. I don't think that's what the rules were intended to say, but you certainly can expect that sort of argument to be made both to tribunals. I've seen it made by counsel opposing us, and in national courts, and clarification of the extent of the tribunal's authority with respect to virtual hearings and other sorts of things that may need to be done as a consequence of the pandemic probably couldn't hurt.
Thank you. Kevin, would you like to add?
Yeah, under the SIC rules, tribunals already have broad discretion on costs, and we specifically provide for the possibility of hearings by video in our Schedule 1 with respect to emergency arbitration. One thing that SIC has done through its entire history really is listen to its users, and this is what Gary has been doing as president of the course by hosting all of these user dialogues. So if you look at the evolution of SIC, introduction of expedited procedure, emergency arbitration, early dismissal, one important point when we look at how early dismissal has become enormously popular under the SIC rules, tribunals always had this power inherently, but by codifying it and putting it in the rules, it gives tribunals a little bit more courage, and it gives something for enforcement courts to look at. So that might be part of what we want to do in the upcoming revision to the SIC rules, is to encourage virtual hearings. So if you put it in the rules, even if it's already there and that broad discretion exists, this may help make it more and more this new normal.
Thank you, Kevin. I would like now to give the floor to Sarah and to hear HKC's perspective on this.
Thanks, Andrei. I would start by saying that I think it's institutions have been thinking for a long time about online dispute resolution and how to change their rules to make that effective. it's not new, but now it's concentrated. So, and at the same time, my impression has always been what parties and tribunals have tended to do in the past is to tag on a virtual tool to what is a traditional in-person hearing when it's necessary. But now we're being forced to convert fully to fully virtual in certain circumstances. So we are catapulted into the future. So I think that there is space for institutions to lead, and I think that a lot of users look to institutions to lead. My sense at the moment is that what is most immediately useful to parties is help with going virtual with their hearings. So we've issued guidelines, we issued those yesterday, and that's an accumulation of some of our experience, some of the issues we see come up again and again. So that's out, and we think that that's practical, that's meaningful, it's useful to parties. In terms of the rules, we did our last revision in 2018. We tend to revise in 5-year blocks. And so in the 2018 revision, we put in place a specific notification provision, which provides that there would be deemed notification if a document is uploaded to any secured online repository that the parties have agreed to. And we have that service available to the parties. So we thought that that would become more relevant going forward, and we see that other institutions have that service as well. Also, we put in our general provisions that the tribunal shall adopt suitable provisions for the conduct of the arbitration, having regard to the effective use of technology. So as Kevin alluded to, that gives tribunals sometimes a bit more courage and black and white in the rules to make decisions that they would otherwise perhaps be less bold to make. And we have in our rules also third-party funding disclosure requirements. I've had a recent conversation with a third-party funder who's very active in Asia, and I understand that there are quite a few cases in the pipeline, some of which are COVID related. So I think that we'll see a bit more activity in that regard in maybe the next 12 months, 18 months. I've also heard from a user that it would be quite a good idea to have a model arbitration clause that provided that all hearings would be virtual. And I have to say I hesitate at that, because when you're drafting your clause, you have no idea or limited idea of what shape the dispute is going to take and how it's going to play out. So I'm not sure that parties will necessarily make use of such a model clause, but you never know, and it may be that a model clause like that would be picked up, and then the market will tell if it is truly useful or not. Thanks.
Thank you, Sarah. Just listening to you, I thought that maybe these kind of protocols on virtual hearings will become a kind of, maybe at some point of time, the exhibit to the arbitration rules of some institutions, like a usual way to handle the arbitration proceedings. I would like also now to give the floor to Patricia.
Thank you. Great. I agree. I think Sarah and Gary and Kevin have made some great points, which I think are relatively transferable to other institutes as well. Let me note that the SEC is not about to announce that it's beginning work on a new set of rules. Our rules now last set of rules came into effect in 2017. And I think that the general consensus of users, the Secretariat, and such is that those rules provide sufficient flexibility to deal with the current issues. And like SEAC, in 2017, we introduced new provisions dealing with joinder, multiple claims arising out of multiple contracts, a new provision. We had an older one on consolidation, and other things which provide flexibility which would be suitable for the current environment. Let me also note that, as Kevin was speaking about, that as regards the early dismissal, the existing discretion which the tribunal had in the old rules would provide sufficient basis for that. And that's similar to the SEC position. By putting it into the rule, it makes it quite clear to the arbitrators and to the parties that that tool exists. Let me also point out something which we might see more use of now, and that is that in the 2017 rules of the SEC, a new provision was added that provides for security for costs. Now, many were of the opinion that security for costs are a form of intermeasures and you don't need a specific rule. Others don't think that, but we now have a specific rule for that to ensure that arbitrators are aware and parties are aware of what that tool is, and it provides some basic guidelines, which you might see look a bit like the Chartered Institute, but they're somewhat different on the guidelines. It'll be interesting to see if in this current environment that we may see security for cost orders start to pick up when claimants are bringing a claim in the hope that that claim may keep them afloat, while respondents are concerned that they won't be afloat long enough to cover any cost order at the end. Let me also point out one other thing that we're starting to see. It's been discussed in the Swedish environment, and I think there's also, if I remember correctly, a recent initiative in London about encouraging court cases to move over to arbitration, because even though the courts in Sweden have become very adept at moving cases through virtual hearings, they are a bit hindered because many people are sick. Witnesses are sick, court staff is sick. In Sweden, we prioritize cases dealing with child custody, criminal matters, etc. And so in the current environment, it can be interesting for parties to move their case over to arbitration. And that opens up for perhaps greater guidance and some assistance in making submission agreements, which in some cases can be a bit complex to make as compared to a model clause put in a contract before you know what the dispute issues are. So I see this as areas where institutional guidance in the form of advice from the Secretariat, in the form of policy statements, in the form of maybe appendixes or new guides, that there is room that we're having to deal with that. And one last thing before I relinquish the microphone, those who are familiar with the Swedish arbitration law probably may be aware, but probably are not, that at least one commentator of the older generation has opined that a hearing according to the rules and a hearing according to the Swedish Arbitration Act means a live in-person hearing. Kevin, Gary, Sarah, Mira, Jackie, aren't you all live? Are you all living right now? Aren't you appearing in person? It's not an avatar. The general consensus is robustly and resoundingly that the rules and the law requiring a hearing is completely complied with in a platform virtual hearing, and that even if a party objects to some of the logistics or even objects to the hearing taking place, that if the arbitrators exercise due consideration of making the logistics provide everyone with a reasonable opportunity to be heard, to manage it effectively, and to ensure equal treatment. Not obviously, parties do not come to arbitration with equal resources, but in order to manage it within that context in a reasonable way, it's the existing framework in Sweden allows for it.
Thank you very much, Patricia. I'm told that we are a little bit short of time, so excuse me, maybe it's my mistake, like not very experienced moderator, but I would like to give the floor to Jackie for some final comments on the LCIA perspective for a couple of minutes.
Thank you, Andre. Three very brief points. I think, first of all, on the rules, I think we're privileged at the LCA that the current rules already explicitly refer to video facilities. I think we're in reasonably good shape. I think we're also in the lucky position that we are about to roll out a rules change anyhow, because we have the view that it's not in users' interest to have too many rules revisions. But since we are going to be launching rules revision in the next month or so, we might be able to pick up 1 or 2 points, but at the same time, I think the current rules are probably adequate for the situation we're facing. Picking up Sarah's point on guidance, I think that's a very valid point. And I would like to stress the need to distinguish between, let's say, emergency guidance and longer term guidance, because I think in the current situation, there's still much more understanding, willingness, and the need to accept solutions which I do not think are sustainable longer term. And Patricia referred to the fact it is genuinely tiring to be sitting behind a screen. It is okay right now if somebody says, can you do this at 2 a.m. in the morning? But if we're structurally going to be doing virtual hearings, there are just limits to what people can do. And so I suggest that for the guidance that we are going to be providing, whether through guidelines or in incidental cases, we really try to distinguish between what needs to be done now, where we should expect people to be a bit more flexible, and what is it that we're taking away from this crisis and make more long-term solutions. And that ties into my third point, which is the court arbitration discussion. I think initially some people thought that this would be a panacea. Well, first of all, I think in some jurisdictions we're seeing, as I said earlier, that the courts are actually shaping up very nicely, so there may be less of a need. I think in some jurisdictions there is definitely going to be an interest in using the facilities that arbitration potentially has compared to court jurisdiction. I see this more as a sort of emergency measure, which may help in some jurisdictions, in some cases. I don't think it's a structural solution. But at the same time, it keeps us all on our toes, doesn't it? I mean, if we can offer something that the courts cannot, then we should strive to do so. But I think we should be also very careful not to use this as an opportunity simply to erode what the courts are doing. I think we need the courts in arbitration, not to act as competitors, but to provide the basic framework that arbitration requires. We thrive when the courts function well. Having said that, I obviously think that we are better placed to provide certain services than certain courts, but I think we should be cautious not to get into a sort of fight between arbitration and the courts as a result of this crisis. Thank you, Andre.
Thank you very much, Jackie. I would like to say thank you very much to everyone. And just to quickly wrap it up, I see that the result of our session is that we are pretty optimistic looking forward. So we see that institutions will be in demand and their role will increase. We see that institutions are already very well prepared for the future life, becoming electronic with the good stuff, with the good rules, and also are happy and are ready to adjust rather rapidly and flexibly. As always, we see that the number of settlements will increase, which is also, I think, generally good. Maybe the role of mediation will grow further, specifically in certain jurisdictions, or maybe worldwide. And finally, maybe this new normal, or as it's called now, will open also some opportunities to new arbitrators, to diversity, and to more practitioners from various jurisdictions to take part in the hearings and to gain experience in international arbitration. So I would like to say thank you very much to everyone. I would like to wish you good luck. Please stay safe. I will miss our networking after the conference for sure, but I am looking forward very much to see you all in person very soon. So please stay safe and always in touch, and good luck to our third session of the conference. Thank you very much.
Thank you.
Thanks, Andre.
Thank you. Okay.
I'm happy to greet you all. Good morning, good evening, good afternoon to all of you. My name is Andrei Shevend. I'm Associate Professor at the Lomonosov Moscow State University. And it's my greatest pleasure to introduce the main person of this part of the conference, Klaus-Peter Berger, who is professor at the University of Cologne, director of the Institute for Banking Law and of the Center of Transnational Law Central, member of the Council of the Institute of World Business Law of the ICC, and a practicing arbitrator with more than 25 years of experience.
Hello.
The main idea of this interview is to discuss some salient points of the paper written by Klaus-Peter together with Daniel Ben, Force Majeure and Hardship in the Age of Corona, a historical and comparative study. The paper is about to appear at the McGill Journal of Dispute Resolution. But now we will be focusing on some points of it. You will be able to send your answers, but unfortunately we will have time for only 2 or 3 of them. So there will be some pre-selection and I'll hope that our plan will be satisfying anyway. So before we address our actual subject, just one preliminary question outside its scope. These days we are witnessing a worldwide outburst of ad hoc emergency legislation trying to give a legal response to the COVID-19 pandemic. Can you briefly provide some examples?
Yes, and first of all, thank you very much for inviting me to this very interesting event, kind of an unforeseen assignment for me. And I think unforeseeability is definitely the subject of this hour. And if you ask me to provide you with some examples and you say that's outside the subject, I don't think so, because I think that there are certain examples of legislation, emergency legislation around the world, which are directly connected to our subject. And I want to give you just 2 or 3 examples to show you what I mean. And the first one, it's not surprising, comes from China, the country of origin of the COVID-19 pandemic. And on February 10, 2020, the spokesperson of the PRC's Legislative Affairs Commission of the National People's Congress Standing Committee, long name, announced that measures which were implemented by the Chinese government to combat the virus and which might affect contracts with foreign companies should be considered as force majeure events. And in line with that statement, the China Council for the Promotion of International Trade, which is a quasi-governmental body, then issued a large number of so-called force majeure certificates. As of March 25, they had issued 6,500, almost 6,500 of these force majeure certificates, covering a total value, contract value of almost $90 billion US. And these certificates were intended to protect Chinese companies who could not perform due to the crisis from any legal consequences in their contracts with foreign companies. Some days later, February 28, 2020, the French Ministry of Economy stated that the COVID-19 pandemic will be considered a force majeure event and that penalties for late deliveries will not be applied, at least in public procurement contracts. So that was limited to public procurement contracts. And we have similar legislation now around the world, for example, in Iraq, and the latest one in Singapore. So there is a large array of domestic legislation, emergency relief legislation, if you want, that is directly linked to the notion of force majeure. So the focus initially seems to be on force majeure, but the picture is wider, as we will discuss in a moment.
Well, but you, in your paper, you address primarily the two well-established tools of ordinary contract law, that is to say, force majeure and hardship. Could you please put these two into perspective with respect to the fundamental principle of pacta sunt servanda?
Yeah, I think that's a very important point that you're raising, because very often, if you listen to the debates that we have at the moment, people speak about force majeure, speak about hardship as if these were principles with no foundation, but that's wrong. And it's very important to put them into this perspective of pacta sunt servanda on the one hand and clausula rebus sextantibus on the other. And that is, as you know, this eternal conflict that we have in contract law. If you look at the pacta principle first, I think it's clear that this theory says and regards a contract as a deal. A contract is a deal. It's a discrete transaction in the form of a mutual promise, and the promise must be kept, period. My word is my bond. I trust you and that you will perform, you trust me, and that's our transaction. And so contracts must be kept in an absolute manner. This is the initial idea of the pacta principle many centuries ago, as it was developed in those days. Today, it's I would say, a foundation of civilized society, of most civilized contract laws. It's also an undisputable rule of international law, public international law, and essentially it's based on the autonomy of the parties, which provides the moral justification for the pacta principle. And because it's the autonomy of the parties, the rule is that the parties should take care of unforeseen circumstances. And the French have a very nice saying, or an author said that, contrater, c'est prévoir, which means to contract means to foresee. So the parties need to foresee that and need to take care of these circumstances. You can see already, I mean, it's impossible. No one foresaw the pandemic. And so that is, of course, a very theoretical approach. And that's why it's very important to look at the second principle underlying the two notions of hardship and force majeure, the clausula principle, clausula rebus. And that is based on the idea that the continued enforcement of a contract is always subject to the continued existence of those circumstances which existed at the time when the contract was concluded. You, Andre, you know the famous lawyers Bartolus and Baldus in Italy who phrased this term. There's a rule that every promise is to be understood with the circumstances being the same. And that is derived essentially from good faith, because good faith is a principle that implies a standard of behavior which, among many other things, says that no party should enrich itself at the expense of the other in such an unforeseen scenario, a scenario which was unforeseen at the moment the contract was concluded. So this is the basic framework that you just mentioned, and I think it's very important to bear that in mind when we speak about the need to find the right balance between pacta sunt servanda and clausula rebus, the impact of changed, unforeseen changed circumstances.
What would be precisely the difference between the two concepts in question, and are they really apt to cope with this extraordinary current situation?
Yeah, you mean the principles of force majeure and hardship. That's of course one of the core points here in our debate. What are these principles? What are their prerequisites? And how can they deal with the COVID crisis? And it's very important to draw this distinction between the two principles, because in reality, that distinction is often not done properly. And there are many reasons for that. One reason is that in the international contract practice, you very often find contracts which have both a hardship and a force majeure clause, and both clauses deal with the same subject, the effect of unforeseen circumstances. There is also an indication in the UN Sales Convention that we have to be careful here, in the distinction of the two principles. There is, as many of you will know, an Article 79 of the CRSG, which is essentially a force majeure provision. An impediment beyond the control of a party may lead to the excuse of non-performance of that party. But there is today a general view, I would say, that under 79, which is a force majeure provision, certain hardship scenarios can be put. For example, if there are genuinely unexpected and radically changed circumstances in truly exceptional cases, that may qualify as a case of 79. But that would be a hardship scenario, which is put under the force majeure provision of 79. So the fathers of the UNIDROIT principles, you know the UNIDROIT principles of international commercial contracts, they have stated there may be factual situations which can at the same time be considered as cases of hardship and of force majeure. So it shows you that you have to be very careful and you need to distinguish these two principles. Now, in theory, it's very simple. If you look at force majeure first, force majeure relates to impossibility. So due to a certain event, I come to that in a moment, it is impossible for a party to perform. So force majeure is essentially a way to excuse non-performance of a party due to exceptional circumstances. That would be a very general description of the force majeure principle. And if you look at the various transnational rules that we have on this, you will find, for example, 79 CRSG, I mentioned that already, but you will also find 717 of the UNIDROIT principles, which is the provision that contains the force majeure principle of the UPIC. I call them the UPIC, the UNIDROIT principles. And if you look at that provision, you see, and also at other rules, there are four requirements of that force majeure principle. The first requirement is you need an external event, a drought, a civil riot, or maybe also a pandemic, or maybe an embargo, or whatever. So you need an external event. The second requirement, you need unavoidability. So the occurrence of that event must be beyond the obligor's sphere of control or the ordinary organization of his business. The third requirement is this classical requirement of unforeseeability. The event and its consequences, that means the adverse impact on the obligor's ability to perform, could not reasonably have been avoided or overcome by the obligor. For example, by alternative and commercially reasonable modes of performance, procurement of transportation, and so forth. And the fourth requirement would be causation, the so-called but-for test. The obligor's non-performance was caused by the external event and not by the obligor's own fault, for example, by self-inflicted production problems, defective goods, packaging, whatever. So these are the four requirements of the force majeure principle: externality, unavoidability, unforeseeability, and causation. And if you go to unforeseeability and you come to the COVID crisis, everybody tells you it was unforeseeable. Well, it certainly was up until February 2020. There is a very interesting study by the German Robert Koch Institute. You may have heard of that institute before. It's the government-run medical health institute in Germany. And they published a study. It's very interesting. The date of that study was January 2013. So in an official parliament document, they published that study, and they said that a hypothetical pandemic, like the one we are facing now, was qualified as conditionally probable. That would be the literal translation, which means, and that's what they said in the study, an event which, and I quote, statistically would occur once in a period of 100 to 1,000 years. Now, what does it mean with respect to foreseeability? Well, at the same time, that study says that the scenario, the COVID-19 scenario, similar scenarios, were not foreseeable per se, because no one could predict when exactly and where exactly such a pandemic would occur. And it's not possible to put businessmen under, if you want, permanent alert, so that they always have to think about the question, would there be a pandemic? No one would expect this So that in the words of, I would say, the author who wrote the seminal study, the most important study on force majeure and hardship, Christoph Brunner from Bern in Switzerland, the pandemic, the COVID-19 pandemic, must be characterized as, and I quote, an event so unlikely to occur that reasonable business parties see no need explicitly to allocate the risk of its occurrence, although the impact it might have would be of such magnitude that the parties would have negotiated over it had the event been more likely. So it was unforeseeable. It must also be unavoidable, and that is a different prerequisite. You have to see whether in a given case that was indeed unavoidable, the non-performance of that party caused by the unforeseeable event. These are two different prerequisites, but in general, I would say that if we look at the severe consequences that we are facing at the moment, it is easier for a party under these conditions to prove that prerequisite. It is important to mention that the party who invokes force majeure bears the burden of proof for it. And my last point on force majeure is that if you look at the clauses that you have in the contract, if you look at the UNIDROIT principles, if you look at 79 CRSG, there's always a notification requirement. So the party that is faced with a force majeure event needs to notify the other side of that event. If it does not notify the party, it can still invoke force majeure, so the defense is not forfeited. However, it has to pay damages, all damages that arise with the other party because it was not notified in time and could not avoid losses. So much for force majeure. So I would say, answering your question, that yes, the force majeure principle is flexible enough, is also specific enough, so both, to be able to cope with the problems that we are facing at the moment. Hardship, on the other hand, is different insofar as it does not require impossibility. It just requires that performance of the contract becomes commercially more onerous for the same external events which I have just mentioned. So the requirements are very similar: unforeseeability, unavoidability, an event, an external event. However, the nature is different of that defense. It's not required that the performance is impossible. It just needs to be economically more onerous. For example, because the cost of performance is dramatically increasing, or the value of the performance that you receive is decreasing. I will not go into the details now of the various rules in common law and civil law countries, but if you look at the transnational rules, and that is my subject here to answer your question, you find in the UNIDROIT principles in Article 6.2.1 and follows provisions on hardship, which shows you that the drafters of the UNIDROIT principles thought that this is a transnational principle. But it's interesting that they start with a very simple proposition, which brings us back to your first question. And 6.2.1 says of the principles, where the performance of a contract becomes more onerous for one of the parties, that party is nevertheless bound to perform its obligations, subject to the following provisions on hardship. So the rule is pacta sunt servanda, the exception is hardship. And there was an ICC tribunal who said some years ago that the clausular principle is, and I quote, a dangerous exception to the principle of sanctity of contracts, whose application must be limited to cases where compelling reasons justify it. And that's exactly what the hardship provision says in UNIDROIT and also in other rules. You need a fundamental alteration of the economic equilibrium of the contract. The party invoking hardship must be faced with an excessive economic burden. That is something that needs to be distinguished in each individual case. And if you have a hardship situation, then the legal consequences are different from force majeure. You can require the other party to renegotiate the contract. If the party doesn't agree, the other party, you can go to the arbitral tribunal and ask the tribunal to adapt the contract or to terminate the contract. So I think you see here that with respect to hardship, hardship is more flexible in terms of the legal consequences. Adaptation can be a very interesting option for the parties, in those cases where performance is still possible, but not under these conditions. So we have force majeure on the one hand, providing a permanent or temporary excuse, nothing more. And we have hardship, where the legal consequences are much more flexible in terms of this notion of adaptation of the contract.
There is one more pointed question from the audience. Perhaps 2 or 3 words on it. Can the force majeure principle be applied to pecuniary obligations?
It can be applied to any type of obligations. Force majeure is not limited to, for example, the contractual obligation to deliver goods. Force majeure is a general principle that applies, if you want, across the board.
Thank you. Well, in your paper, you address also the widespread practice of putting force majeure and hardship clauses into international business contracts. Are these clauses, are these contractual agreements sufficient to cope with the problems caused by the COVID-19?
I would say that the parties to these contracts, they think that these clauses are sufficient. They think that the clauses are perfect and provide legal certainty, but we as international arbitrators, we know that this is in many cases not the case. And there are many reasons for that. I will just mention 2 of them briefly. The first reason is, does the COVID crisis fall under the force majeure events mentioned in the clause? Now, if you're lucky, you have a clause that lists as possible force majeure events, for example, diseases, plagues, epidemics, health emergencies, or similar health-related situations. That's fine, because then you have no problem of putting the pandemic under the force majeure clause. But there are clauses that do not mention health-related events. If these clauses mention natural disasters or extreme natural events, that might be fine, because the COVID crisis has been characterized as a, and I quote, natural catastrophe in slow motion or a natural event. So you might draw a parallel between natural disaster and the COVID crisis. Now, if you have clauses that do not mention natural disasters and natural events, then sometimes you have open clauses. Often, I would say often, you have open clauses, which means that they have a list of events, but that list is non-exhaustive. And at the end, you find words like, and any event of a similar nature. And then you could say, well, the COVID situation is certainly an event of a similar nature. So one problem with these clauses is the question, the classical question of whether the event, it's the COVID crisis here, falls under the definition of the events used in the clause. The other problem is a problem that the drafters typically do not think of, but it was the subject of 2 leading ICC arbitration awards. And I can just tell you perhaps that the ICC has published, ICC Institute, you mentioned that I'm a member of the council, has published a very good dossier on hardship and force majeure in international commercial contracts. And I had the chance to deal in that book here with that second problem, which is the relationship between the clause in the contract and the applicable law to the contract, because many of these laws contain provisions on force majeure. And then the question is, what is the relationship between the clause and the law applicable to the contract? The first award is a very well-known one, National Oil Corporation versus Libyan Sun Oil Company, ICC Award 4462, which was rendered in 1985, which was published, and there are a number of articles on it, where the parties, on the one hand, a US company, National Oil, Libyan Sun Oil Company and National Oil Corporation from Libya, they concluded a production sharing agreement, and there was a force majeure clause in the production sharing agreement. The question arose whether the provision of 360 of the Libyan Civil Code on force majeure must be read into the clause, and the parties remained silent on this question, and they had different views on this, and the tribunal said that in the absence of an express exception, the force majeure provision could not be construed to exclude the essential requirements of Libyan private law. So they said that the requirements of force majeure from Libyan private law must be read into the clause, because the clause remains silent on the relationship between the law and the clause. Now, in the second award, second leading case, ICC award number 19299, Gujarat State Petroleum Corporation and others versus Republic of Yemen and others, under the presidency of my good friend Laurent Lévy from Geneva, the tribunal was faced with the same question, but reached a different conclusion. The tribunal said that because of the specific and precise wording used in the clause to describe the force majeure events, that language included requirements of Yemeni law on force majeure, while leaving out others. The conclusion can only be that the parties wanted to set up their own independent force majeure system. So two ICC awards dealing with the same question, but reaching different conclusions. One reason for reaching different conclusions was that in the second case, the Gujarat Petroleum case, the force majeure provision was much more specific, more elaborate. And so the tribunal had more arguments to say that the parties wanted to establish their own independent force majeure system, independent from the applicable domestic law.
Thank you so much. Yet another issue. In your paper, you stress that case-by-case evaluation of every given COVID-19 dispute is appropriate. The language of individual contracts and circumstances of each case will often be decisive. Yet there is an obvious need for general guidelines or yardsticks to handle the countless COVID-19 disputes in a coherent manner. So how far is it possible to frame general guidance for the courts or arbitral tribunals faced with the COVID-19 litigation?
That is certainly another important point you're raising here, because I am sure, and many others are sure, that over the next years, if not the next decade, we will see numerous arbitrations involving exactly this issue of force majeure in this COVID-19 situation or hardship. And so I think you're right, there is a need for certain guidance. And I think at least what you can say, well, first of all, it's important to underline, it's a case-by-case analysis. It's very difficult to find generalizations because the principles are so flexible. However, I would say what is very, very important in this context is to draw a clear distinction between the general evaluation of the COVID-19 pandemic from the political side, socioeconomic side, from the health medical side on the one hand, and the legal qualification, our job as lawyers to determine the legal impact. So we need to draw this distinction. And you know that on January 30 this year, the Director General of the World Health Organization declared that the outbreak of the COVID-19 crisis constitutes what they call at the WHO a public health emergency of international concern, which is a pandemic. But that is not for us lawyers, this is not the legally relevant event. The legally relevant event are the factual or legal effects of the pandemic. What does it mean? Well, you know, for example, a tribunal might be faced with factual effects of the crisis, like illness, quarantine, or death of key personnel of the company, production facility closure, interruption of supply chains, typical factual scenarios arising out of the pandemic. And this would be then the event, the force majeure event, which the tribunal or the court would have to deal with. There are also possible legal effects. What are these legal effects? Well, clearly lockdowns, curfews, travel restrictions, and other measures by government and public authorities. So it's not the declaration of the WHO as such. It is also not, and that's very important, coming back to my first point, it's also not a force majeure certificate issued by a public authority. that constitutes force majeure. These Chinese certificates are nice to have, but they cannot bind a court or an arbitral tribunal sitting outside China. They may be regarded as providing an indicative effect for the factual existence of force majeure, but it is the tribunal's prerogative to determine whether such a force majeure situation does in fact exist. So neither the Chinese government, the Chinese authority, or the French authorities can tell us arbitrators whether there is in fact a force majeure situation or not. And that is, and I have to stress this, it's very important, very, very relevant for one specific reason. And that is that there is, of course, a temptation now for opportunistic behavior, meaning that parties might be tempted to use the pandemic as a pretext to try to renegotiate an unfavorable contractual bargain under the guise of a well-accepted principle like hardship. It is sometimes called price majeure instead of force majeure. You know, this temptation to try to renegotiate the deal by saying, oh, we're faced with a force majeure or whatever situation, but you have to look behind the scenes and see what the real scenario is, factual or legally speaking, and then as a tribunal, you can see whether the prerequisites which I've mentioned are really met in the case or not. So I think that would be my most important guidance point for arbitral tribunals and courts for the, well, I would say, years to come.
Thank you. There is a question from the audience concerning the main differences between approaches taken by law jurisdictions concerning force majeure and hardship. In your paper, you indicate that here, as so often, the two worlds diverge, common law and civil law.
Yeah, that's true. That is very difficult to, it's very difficult to provide a short answer here. That is, I would say, the core part of our article. I have to say that we started the article last year when nobody spoke about the pandemic. There was nothing about the pandemic. It was supposed to be an article about exactly that question, the differences in civil law and common law in the handling of force majeure and hardship. So I have to try to be very brief here, like in a nutshell. If you look at force majeure first, you have, of course, a number of civil law jurisdictions that have force majeure provisions in their statutes. The most relevant one is obviously France, because it's a French notion of force majeure. It's the irony that until 2016, the French had only a provision on the consequences of force majeure. They never had a definition of force majeure in their Code Civil for a number of reasons. And it was only in February 2016 when they had a major revision of their contract law, when the French included a new Article 1218 in the Civil Code of France with a provision on force majeure. What does force majeure mean? And let me just read to you this very brief definition from the French Code. In contractual matters, there is force majeure where an event beyond the control of the debtor, which could not reasonably have been foreseen at the time of the conclusion of the contract, and whose effects could not be avoided by appropriate measures, prevents performance of his obligation by the debtor. And then you have a provision that says, well, if it's temporary, a temporary event, then performance is suspended. If it's a permanent event, then the contract is terminated by operation of the law. There are some cases in France dealing with severe diseases where French courts have not accepted that as force majeure. For example, I've never heard of this virus before, the chikungunya virus on the island of Saint Bartholomew in 2013, 2014, and the dengue fever on Martinique. They were not considered as force majeure, but that was decided because of their relatively mild and non-lethal consequences and local limitation. Our case is very different. So I guess, and there are voices in France that the French courts would accept COVID as a force majeure event. Now, in my jurisdiction, we have, in many other jurisdictions, we have provisions on subsequent impossibility. I will not go into the details of that because it would be a long answer. Common law, very difficult, extremely different. I can only tell you that as far as England is concerned, they have developed a theory of frustration, the doctrine of frustration, built on a very famous decision from 1863, Taylor versus Caldwell, where the Judge Blackburn said that every contract has an implied condition, a thing, that, if you want, that is essential to it, and that thing, that condition, must continue to exist throughout performance. And if it does not, then a party can be excused. There is another leading case from 1956, Davis Contractors versus Fareham, where the court has tightened that test and has said, and many other cases have followed, that it must be a case where the nature of the obligation has been changed due to the unforeseen circumstances, where, and I quote, it would be wholly unjust to hold a party to the literal sense of its stipulation under the new circumstance. A radical change of the obligation must be a different obligation. It was not this that I promised to do because of these new situation that I'm facing. It is applied in a very, very restrictive way because parties are relieved from their obligations. So it's difficult to predict whether COVID-19 would be accepted as such a frustrating event. Even Brexit was not accepted by a court as such a frustrating event. My guess would be that, I mean, COVID is a really, really serious, unprecedented, extremely problematic situation that the courts, the English courts, would accept that situation. In the US, I have a different concept, a very similar one with a different name. It's called impracticability. Impracticability. And if you look at the restatement second of contracts, section 261 in chapter 11, it says, and I quote, where after a contract is made, a party's performance is made impracticable without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, his duty to render that performance is discharged unless the language of the circumstances or the circumstances indicate the contrary. So what you have to do under US law is to look at the basic assumptions. It's a common assumption test. What was the basic assumption of the parties? Again, very, very narrow. A US court has said that a contract, a party can be discharged of its obligation under this doctrine only in situation in which a virtual cataclysmic, a catastrophic, wholly unforeseeable event renders the contract valueless to one of the parties. So it's very, very narrowly construed. So much for force majeure. So we have provisions in civil law jurisdictions. The doctrines in common law, they are fighting with this problem. They are very, very narrow. But my guess would be that under the situations that we have right now, the COVID scenario, that even the English and US courts would perhaps adopt a more liberal approach. If we turn now to hardship, the hardship situation, and look to France again. In France, they had a long-standing view. There is no revision of the contract under hardship situations. One of the most famous decisions in France in private law, most famous judgments ever rendered, was the Canal de Capon decision of 1876, where the Cour de Cassation in France refused to adapt a fee for the maintenance of a canal, which was fixed 300 years ago. So it was obvious that the fee was too low, but they refused to adapt it because there was no permission in the law. And they said, if there's no permission in law, we won't do it. Now, there was, if you want, a second revolution in France in 2016, when in the course of this revision of the French law that I mentioned, they now have a new provision 1195 in the French Civil Code, which provides for renegotiation or termination of the contract in case performance becomes excessively onerous for one of the parties. It remains to be seen what the courts in France will do. In my own jurisdiction in Germany, we have what we call the disturbance of the foundation of the transaction, which was until 2002 case law based on good faith, but which is now in our civil code in section 313 of the civil code. And that is if you want a hardship provision which allows if the basic assumptions of the parties that they had when the contract was concluded change, then you can demand renegotiation as a party from the other side, or go to the court, or go to an arbitral tribunal and request the court to adapt the contract. Or if that doesn't work, then the party has a right to terminate the contract. German courts have been very adaptation friendly, even though that doctrine is only a subsidiary doctrine, and we are very careful to avoid to allow for loopholes of parties to escape their contractual obligations. That's for sure. Pacta sunt servanda is still the rule, but the German law, the German courts are adaptation friendly, so that I think that the German courts will be able to cope with the COVID scenario through that section 313 of the German Civil Code, maybe much better than, for example, the English and US codes who have problems with adaptation. English courts will not adapt contracts.
Perhaps a purely speculative question in this context. Do you think that the COVID-19 will force the common law and civil law jurisdictions to breach the divide, to come to similar at similar results in hardship and force majeure litigation?
It could indeed be one of the very, 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 very few good sides of this catastrophe, that in this area of law, where so far the two families of legal systems have been quite apart from each other, will come together. But I have to say that to achieve that, the common law courts have to go a longer way. Because, for example, and maybe also the French, by the way, because so far the French have not been used to adapting contracts. And the question will be, will the French courts now accept that legislative mandate to adapt contracts, even though for the past 200 years they have refused to do it? They didn't do it. The same with respect to English and US courts. I'm still skeptical, but you should never lose hope. I still have the hope that under these extreme conditions, US and English courts might finally come to the conclusion that the concepts that they have, impracticability, frustration, may perhaps also allow them within certain framework to adapt contracts. But that is, the English would probably tell me, well, that is the dreaming of a civil lawyer who does not know our legal system. So I wouldn't dare really to tell English lawyers in which direction their law will apply. It's the same with good faith. You know, I had many debates with my friends about common law friends about good faith, but I'm hesitant to enter into that debate.
There is one specific question from the audience. Is the party, other than the party having invoked force majeure defense, entitled to terminate the contract?
It depends on the statutory provisions which you have, and there are provisions which allow each party to terminate the contract, which gives both parties the right to terminate the contract. So in many cases, the answer is yes.
Okay, let's move on. And the next question is, what specific role the international arbitral tribunals will play in this legal response to COVID-19 concerning hardship and force majeure?
I mentioned already in one of my previous answers that I think it will be a very, very important role. And I think that these tribunals have to adopt a three-tier test. In my view, it's a three-tier test. And these three tiers are this. First, they have to determine the procedural authority with respect to contract adaptation. If we speak about adaptation now, how can they do it? First step, procedural authority, and they have to derive that authority from the arbitration law at the seat of the arbitration. And how can they do it? Well, either the arbitration law has a specific authorization for arbitral tribunals sitting in that country to adapt contracts. You have that sometimes, for example, the old Swedish law allowed tribunals to fill gaps and I think also adapt contracts. Or you have arbitration laws which open the very narrow notion of dispute, which is a requirement for an arbitration, to differences. Differences, that's a much broader notion. So for example, Article 82 of the arbitration of the English 1996 Arbitration Act, or Section 2.1 of the Hong Kong Arbitration Ordinance, they say that a dispute is also a disagreement. And even the International Court of Justice, as early as 1925, ruled in the famous Mavromatis Palestine concessions case, and I quote, "A dispute is a disagreement on a point of law or fact, a conflict of legal views or of interest between two persons. And if parties disagree on the adaptation of a contract, that is not a dispute, that is a disagreement, because no party is claiming something from the other, but they have a disagreement on how to adapt contracts." And so that's the first test. And even if the arbitration law at the seat does not allow for contract adaptation, you may go to the substantive law at the seat and see whether that law contains provisions on contract adaptation. And if it does, then arbitral tribunals sitting in that country should be allowed to adapt contracts. That's the first step. The second step, and we spoke about that, so I'm very brief here, is obviously substantive legitimacy. So what are the provisions in the law applicable to the contract? And that is very often a law that is completely different from the law at the seat. It's the substantive law applicable to the contract because of a choice of law clause. And what provisions do these laws include? And we have spoken about that already, so I will not go into the details. But for tribunals, it seems to me that the most important issue is the third point. And the third point is, what are the adaptation standards that tribunals have to apply? And that is key. And that is also the biggest problem, because typically, like myself, arbitrators are lawyers. So they are used to decide disputes where a party claims money from the other side, and then we render an award, which is about the payment of money. But here, it's different. It's a commercial decision. And so it's more difficult for arbitrators to find the right criteria to decide that case. Also because in many of the contracts, if you have criteria, they are very vague, like fair and equitable, reasonable, or modify the contract along the lines of the philosophy of the present agreement. What does that mean? If you go to gas price adaptation cases, you have, of course, very, very specific price adaptation clauses with a very specific formula. But in general context, you don't. And if you don't, then what would be the rule that you would apply as a tribunal? And there I would say what you apply is the so-called economic equilibrium rule. The economic equilibrium rule, you find this also in the UNIDROIT principles, means that the arbitrators shall always strive to re-establish the initial economic equilibrium, if you want, the economy of the contract between the parties, on the basis of a comprehensive evaluation of the industry, of the contracts, of the parties' interests. Now, the problem in the COVID scenario, of course, is it's in most cases it's not possible, because the consequences are so severe that a tribunal is not in a position to re-establish the economic equilibrium. And so what does that mean then? It's not possible to remodel the initial bargain of the parties. And then the only thing a tribunal can do is to ensure a fair distribution of the losses between the parties. And we have a debate at the moment here in Germany. What does that mean? And you must probably go back to this very simple rule of 50-50, a 50-50 distribution of the losses, unless you have, and that's very important, in the contract an indication that one of the parties is supposed to carry a greater share of the loss. But because the COVID-19 crisis is so unforeseeable, that's highly unlikely. So that in essence, the only thing that tribunals can indeed do is to ensure a fair distribution and equitable distribution of the losses between the parties rather than re-establishing the economic equilibrium. It is simply not possible in these very severe conditions.
Thank you so much. In your paper and in this interview, you address mainly the law as it stands. My further question is, to what extent do the existing contract laws need to be amended or supplemented in view of this extraordinary developments we are experiencing now?
I think that this is really a key question which brings us away from the current situation into the future. And it seems to me that with that question, you are kind of in the forefront of the debate, which is only starting right now. And I can tell you that as a reaction to our article, I received just a week ago a very interesting article in French from a colleague from the University of Fribourg in Switzerland, Pascal Pichonnat. And Pascal Pichonnat, in that very, very interesting article, discusses exactly that question in French, un droit contractuel extraordinaire. So do we need, your question, do we need an extraordinary contract law? And he has 4 propositions here, which I think are very interesting. 4 propositions. First proposition, oblige the parties to renegotiate the contract. Well, that is something I told you already. We have that in a number of jurisdictions. We have it in the unit droit principles. So we have it in many civil law jurisdictions, this duty to negotiate in hardship situations. It's interesting that a Swiss scholar is mentioning this because the Swiss have this principle of clausula rebus in their law, which essentially means exactly that, renegotiation of contracts. So in my view, from my point of view as a German lawyer, we wouldn't need to change the law here because we have the duty to renegotiate already in our law. The second proposition, take measures to avoid abuse of a law, abuse of contractual powers of the parties. Well, that's something I mentioned earlier. We have to avoid opportunistic behavior of a party that tries to renegotiate a deal under the guise of a well-accepted legal principles like hardship. And that is something that arbitral tribunals need to be wary of, and domestic courts. I don't think that we need a specific provision, provided that all the decision makers know that there is a danger of opportunistic behavior here. 3, and that is highly interesting, Pascal Pichonnat suggests to offer he calls it a group system, a system of group negotiations. So he says that all the players in a certain industry should sit together at a table, even though they are not linked together with contracts, all of them. They should sit together, discuss these issues, maybe with the help of what he calls a COVID-19 mediator who makes proposals, discusses with them the problems, and then these players can go back to their contract partners in that industry. They may find different solutions, but they can always go back to the benchmark, which would be what the mediator negotiated with these people at this negotiation table. This is in essence Pascal's message. He says that because of the systemic nature of the COVID-19 pandemic, we need systemic solutions for risk allocation, which should include all players. So that's kind of a soft approach, ADR approach, which I find extremely interesting, not only because I'm an ADR practitioner, also because it's being discussed already, also here in Germany. But here, I think Pascal Pichonnat is very explicit in this proposal. And then the 4th is very unusual. He says that domestic legislators should allow to extend the contractual effect of bargains to all contract partners, kind of a collective bargaining, like in labor law, we have this collective bargaining approach where a deal struck between a union and a company extends to all workers in a certain industry. That goes very far, I think. I like Pascal's proposal number 3, this system of group negotiation as with respect to number 1 and number 2, the duty to renegotiate and the need to avoid opportunistic behavior, misuse of the law, at least from my perspective, and also from the perspective of transnational law. I think we can cope with that already with the instruments that we have. So there are certain interesting notions, but I would say that I don't think we need a new law. Let's put it this way. I think we can cope very well with the instruments that we have, both on the level of my jurisdiction, Germany, but also on the level of transnational commercial law.
Now that we are talking about extraordinary contract laws, I would propose another perhaps speculative question. At the end of your paper, you argue that, and I quote, "In such extraordinary times, the doctrines of force majeure and hardship assume the role of regular rather than exceptional legal remedies." Do you believe that the COVID-19 pandemic might make judiciary less reluctant to apply force majeure and hardship doctrines in general, and thus strike the balance against the pacta sunt servanda principle differently?
Yeah, that is indeed the essential question that we have to ask ourselves. We touched upon it already when I answered a previous question. If you look at the present law as it stands on the transnational level, force majeure and hardship, it's still these are still narrow concepts. They are narrow concepts, and as you just said, they are exceptions to this fundamental principle of pacta sunt servanda. But if you look at the underlying rationale for that, it is because the law and also courts and arbitral tribunals, they emphasize the accountability of parties to commercial contracts for their own business affairs. Actually, there is a transnational principle developed by ICC tribunals, a presumption of professional competence, which makes tribunals reluctant to interfere with contractual relations. So our notion as arbitrators is that parties, they are sophisticated, or they are presumed to be sophisticated, so they should be able to get along with the problems that they have, which is why up to now, arbitrators were very reluctant to apply these principles. But if you look at the scenario as you just mentioned, these justifications, they lose much of their legitimacy, because in a COVID-19 scenario, self-determination is dramatically reduced. Self-responsibility is dramatically reduced. So that my view is that indeed, as we said here at the end of our article, while the two principles, force majeure and hardship, have been regarded as exceptional remedies and will be regarded as exceptional remedies in the future, now they are suddenly assuming the role of more or less regular remedies, simply because of the extreme nature of the situation in which we find ourselves at the moment.
Thank you so much, Klaus Peter. I think we have to be closing now. Thank you for your instructive and stimulating talk.
My pleasure.
And for your even more instructive paper that everyone will be able to read soon in McGill Journal.
They can read the paper now because the paper is on SSRN, the Social Science Research Network. We are very proud, Daniel and I, because we were informed by SSRN that it's in the top 10 list of a number of top 10 lists which they have on SSRN. So if you go to SSRN and you just type in my name or Daniel's name and then force majeure, you come directly to the article.
Thank you so much.
Sure. Thank you very much. Bye.
Bye.